Yo, 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 what up, everybody? So on time, it's freaky. So on time, it's freaky. So I learned about these oral arguments that were being made with respect to motions to quash. And let me give you all some context before we start watching this. I could have done this tonight, but I didn't know how long they were going to run. They ended up actually finishing just a little bit ago. But I really, really want to watch oral arguments here because I think the oral arguments give us a feel for what we should anticipate with respect to any potential evidentiary hearings. So most of you are aware of the background facts, and I'll summarize for those of you who are new and are not aware as to what we are about to watch and want some context. So in the Geaorgia RICO proceeding that Trump has been charged with, he had at 1.19 co-defendants at current. I think it's closer to like dozen or so because some of them have turned on him. One who has not yet turned is a co-defendant by the name of Michael Roman. Michael Roman's attorneys filed a motion to disqualify Fani Willis and Nathan Wade from prosecuting the case based on their purported special interest in this case, that they have a financial benefit from this case, stemming from the fact that Fani Willis purportedly hired Nathan Wade based on a personal relationship that she enjoys with Wade, we assume enjoys, and that she has now been pushed beyond seeking out justice, the way this attorney is charged with upholding, into a personal basis to try and obtain and invest more money and efforts or even punishment to the named co-defendants, including Michael Roman, and that this is an obstruction of justice. It's an injustice that she's carrying out and trying to proceed with this. Now, Donald Trump's attorneys have joined into Michael Roman's motion, so we should anticipate that whatever the result of this motion is with respect to Michael Roman, it similarly would apply to Donald Trump. It's hard to see much basis for a distinction between Roman and Trump with respect to these particular charges, and more specifically with respect to this motion. So that being the case, there was an initial filing by Michael Roman. There was opposition that was submitted by the state. Most notably, the evidence that was submitted in that opposition was an affidavit from Special Prosecutor Nathan Wade, wherein he admitted that he and District Attorney Fani Willis were engaged in a personal romantic relationship. He claimed that their relationship did not begin until after he had been hired as special prosecutor. Responding thereto, Michael Roman's attorneys say that they have evidence which shows that their relationship had commenced before he was hired to be a special prosecutor in this particular case, and that's why he was hired here, and that Fani Willis is further personally benefiting in the sense that he is making expenditures. He's buying her lavish gifts, taking her on cruises, using the money that she is paying him in part to finance their romantic relationship. They charge trips to Belize and to Aruba on cruise ships and numerous trips, in addition to other expenses that Nathan Wade purportedly expended on his girlfriend, Fani Willis. Now, they also claim that they have evidence to refute the affidavit of Nathan Wade from various witnesses who they say will attest to the fact that this relationship preceded the hiring of Nathan Wade as special prosecutor in this case. And that accordingly, the entire case that has been brought against both Michael Roman, Donald Trump, and one would assume all the co-defendants in this RICO case has been tainted and should be dismissed. Now, when they're seeking dismissal here, it's important to note that what they argue is that much like when a law firm has an attorney who is considered to be someone who is tainted, that would apply to, that could and often will apply to the entire firm. Similarly, the taint that Michael Roman and Trump are seeking to attach to Fani Willis and to Nathan Wade would attach to their office, which would be the entire office of the district attorney, i.e., that these charges must be dismissed because there's nobody who's fit to prosecute them. That is essentially where we are at. Now, that's where we're at with respect to issues that we've discussed here on this channel. In addition thereto, some of the people who have been named have filed motions to quash, saying, my testimony is not necessary here. I don't want to be dragged into this. I don't want to be brought in. I don't want to have to deal with this. I don't want to have to supply evidence. There are various, because what Michael Roman did in anticipation of a potential evidentiary hearing, whereby the court would sit and sift through the facts and try to figure out, was there an inappropriate relationship that led to the hiring of Fani Willis and motivated this prosecution to move forward that warrants a dismissal of these charges. Well, various parties who have been subpoenaed by defense counsel are basically saying, we don't want to come here. And they filed, and even though they were served the subpoena, they filed motions to quash, saying, hey, if and when there is any evidentiary hearing, we don't want to have to, I don't want my client being dragged in here and being forced to testify. And that is what we're about to hear now. We are about to hear whether or not there is going to be an evidentiary hearing, likely, and whether and who will be successful in quashing that motion. Any person who is defendant in quashing that motion, we can anticipate, would in one way or another hinder the defense's ability to provide sufficient evidence to warrant a dismissal of the case. In other words, every person who was subpoenaed is, one would expect, a piece of the puzzle, of the factual puzzle, the factual background, the factual evidence that Roman and or Trump could bring in as a basis to establish to the court's satisfaction that the facts here lead to a legal conclusion that the case has to be dismissed. Well, every piece of the puzzle you're missing makes it less likely that they'll be successful in that. So if you are hoping that this case gets dismissed, you're certainly hoping that these motions to quash are as many as possible are going to fail, and that the motions will be denied. So we're gonna hear from the judge. We'll get it'll be our first opportunity to really hear how he feels about this particular motion, this application. And without further ado, I present to you the hearing.
Morning from Mr. Roman and the other filings of the parties up to this point.
This is going to disappear
in an effort to narrow the issues of what.
That's the judge talking right now. That is, and this thing that's blocking is the court feed itself. That's not me, but that's going to disappear very shortly.
We're here for today. The first one that I would address is the argument that appears in the reply briefs for Mr. Roman about whether quashal is even an appropriate remedy for what we're here for today. Focusing in on OCGA 24-1322. And just as that initial argument goes, I do find that the article of the code dealing with these subpoenas doesn't make a distinction between a subpoena for the production of evidence and the production of testimony. And that's for several reasons. I think what plain reading of the statute at issue doesn't limit quashal to just one type of subpoena. And I'd note there's a previous section of the article that explicitly defines the term subpoena to include both production of evidence and testimony.
So Roman argued essentially that your application to quash a subpoena to be testifying is not the same thing as an application to quash evidence, saying I don't need to turn over these records, which is what the most common type of quashing we see when there's a subpoena that's served by an attorney, and the response is a motion to quash by the recipient of the subpoena. And remember, these recipients are not parties to the case. They're usually, in most cases, not always, but in most cases, they're non-parties who are served with a subpoena. So Roman brought an application, issued these subpoenas. The recipients of some of these subpoenas say, hey, I don't want to have to testify. Roman responded by saying, you can't quash testimony. The judge just said, I don't see much of a distinction between testimony and other types of evidence. So I don't think that procedurally there's a problem with them bringing a motion to quash their testimony. And accordingly, it seems as if he's going to be hearing their applications and whether quashal is appropriate.
I would also point out the Joyner case cited by defense counsel was explicitly decided in the context of a 24-1322 subpoena. And looking at the persuasive authority of Daniel's criminal trial practice, he directly addresses the question and points to at least one prior appellate decision who's addressed quashal of a witness's testimony. And that was a Clark case from the Supreme Court, 240 Georgia 289. And then just ultimately, I think that Rule 403 is going to be able to allow the court to bar testimony of a witness completely. And so I really think it might be a distinction without a difference. But ultimately, we end up at the point where, in summary, I'm finding that the motions for quash that we're all here for today are procedurally right for review.
So in other words, we're going to go forward with listening to the motions and the basis for your request to have your subpoena quashed. Just because you asked to have it quashed doesn't mean the court's going to agree with you, and they may compel you to come in. So, but he said you have a right to make the application, even though it's about testimony. So Roman is incorrect on that score, that there's no right to seek to quash. However, now we're going to proceed to see whether or not quashal is appropriate or whether these witnesses will be compelled to testify.
The next issue, I think a little more to cover here. Again, just to set the stage of where we're at, and I'll allow counsel to weigh in when we get to it, but just want to
I will point out here that as of yesterday, we did not know whether or not there's going to be an evidentiary hearing. The prosecutor claimed that there should be no evidentiary hearing, that there's no need for an evidentiary hearing. Roman vehemently opposed that claim. And it seems as if the judge at this point, at least, we don't know what happened before they turned the Zoom cameras on, but at this point, it seems as if the judge is taking as a foregone conclusion that, yes, a hearing is going to happen here.
Make my initial observations and findings of where we're going today and the rest of this week. So several of the motions to quash today are arguing that we shouldn't have a evidentiary hearing at all, and that quashal is appropriate on those grounds. So to that end, in studying the law that's been filed up to this point, I think it's clear that disqualification can occur if evidence is produced demonstrating an actual conflict or the appearance of one. And the filings submitted on this issue so far have presented a conflict in the evidence that can't be resolved as a matter of law.
What he's saying is we need more facts here, that there could be a legitimate legal basis to disqualify Fani, and that we need more facts here. This is saying we need an evidentiary hearing.
Specifically looking at Defendant Roman's motion, it alleges a personal relationship that resulted in a financial benefit to the district attorney, and that is no longer a matter of complete speculation. The state has admitted a relationship existed, and so what remains to be proven is the existence and extent of any financial benefit, again, if there even was one. So because I think it's possible that the facts alleged by the defendant could result in disqualification, I think an evidentiary hearing must occur to establish the record on those core allegations.
Yes.
So
yes. So we're not going to have the evidentiary hearing now, but he's saying we are going to have an evidentiary hearing. He's likely to schedule it during the course of this hearing at some point later on. Denise says, hi, Joe. Happy Monday. I'm a new member of the Not a Cult Like Cult. There you go. Welcome aboard. Welcome to the following. Excited for getting acquainted with the following. We're excited to have you. The following is all about greater unity, community, and personal growth. So welcome aboard. If you want to check out the chat that's going on, there is a chat that's set up in there right now. Well, there's only a handful of people in there, but that is on locals. So I recommend you check that out.
Just to emphasize, I think the issues at point here are whether a relationship existed, whether that relationship was romantic or non-romantic in nature.
So here, this is important. He's laying out the facts. Thank you. Love you too. He's laying out the facts that are going to be at issue here. This means what he's so whether there was a relationship, whether it was romantic,
when it formed, and whether it continues. And that's only relevant because it's in combination with the question of the existence and extent of any personal benefit conveyed as a result of the relationship.
Oh my God. Fani must have been dying when she heard this. Fani and Nathan Wade were melting into their stupid bench chairs. Although, yeah, I think he probably was sitting up front there. It's hard to see It's hard to get a good view here. This is like the last thing that they wanted. Oh my God. We are now going to do a surgical and legal analysis of your relationship. This could be great. This could be great. So he's like, I told her I liked her not as a friend. in January 20, I told her not as a friend. He said that he was gonna be there for me. He can be my man. It's gonna turn into Maury. It's gonna be like we're gonna hear like we're gonna see the gallery just chanting Maury, Maury. Who the father? We need to know who the father of this baby is. Oh my God. This is gonna be look, I gotta tell you something. Okay. This entire, in my personal opinion, this is not legal analysis. This is my personal opinion. I believe that these charges are ridiculous and that this is a political persecution and this is a terrible affront to justice. This is not the imposition of justice. This is the imposition of injustice. This is weaponization of our Department of Justice, or at least the Georgian Department of Justice in this particular instance. So in that sense, I'm angry that this is here. But once we're here, oh my God, am I salivating over this? I am going to cover this hearing back to front. I'm going to tell you, I will be sitting. I have to hold myself back from flying down to Fulton County to actually watch this. I don't know when it's going to be, but I can assure you, I am covering this front to back. I am not going to miss a moment of testimony in this. I can't even believe this is what our political world has come to. A wrongful accusation leading to an inspection of the district attorney's personal relationship with her special prosecutor, where we're going to have to find out when did you send Valentine's Day cards? What did you buy her? What gifts did you buy her? And they probably going to be able to get access to his records, his to see what monies he spent. Who knows what the heck they're going to get access to? This is this is unbelievably like salacious. The scandal of Fani Willis is something that I'm not shying away from that for even a moment.
With that being said,
when is the first time that you engage in conjugal relations? Where was it? In the back of a Wendy's? like what are we going to hear? We don't know what we're going to hear. We don't know what we're going to hear here. This is amazing. He left his wife. He divorced his wife. At some point, let's put it this way. I would just want to point this out to you. Okay. He divorced her right after he became a special prosecutor. And the claims are that that their relationship began before he became special prosecutor, which means that Fani Willis was the other woman here. This is unbelievable. Play stupid games, win stupid prizes. Yeah, no doubt.
I don't think that means that everything that has been raised in the defendant's motions and Mr. Roman's or in the ones adopted by co-counsel demand an evidentiary hearing. The testimony that would be produced at this hearing is not a deposition. It is still subject to the rules of evidence. And so I think the facts that are going to be developed on the record have to have some relevance and some materiality. Now, contradiction.
When you have a deposition, relevance is not a valid objection. This is the point that the judge is making. Because this is an evidentiary hearing, this is not going to be a deposition. You can't just start asking him about things that are irrelevant. So they're going to be relevance will be a valid objection at this hearing, or in this motion to quash, one would assume.
How things play out could impact that, could change what is relevant. But at the outset, there are a few things that I don't think are. So to that end, I don't think the particulars of Mr. Wade's experience are relevant. I don't think those are material for an evidentiary hearing.
That's interesting, because that's one of the things Roman made a big deal about. He was saying the only reason he was hired was because of his personal relationship. So, and that he's not qualified to be doing this job. And the judge is saying, I'm not going to entertain that. Okay.
His alleged lack of experience handling RICO cases or any inferences regarding the intent from that can be addressed at argument. But in my mind, as long as a lawyer has a heartbeat and a bar card, that lawyer's appointment standing alone is a matter within the district attorney's discretion. Similarly, I haven't found a reason to find that the regulations or the alleged violations of Fulton County Code are relevant in and of themselves. I think the violations of these rules can be argued as a matter of law if counsel wish to do that, but I've yet to see case law or anything indicating that these violations, if they did occur, are relevant to disqualification or a pending criminal case.
That's an interesting interesting legal conclusion that he has, that even if there's a violation, that doesn't mean that the case would be even if there's a violation of her her ethical guidelines, that would not kick in to dismiss the case in his legal opinion. That's interesting. That's arguably an appealable thing, but he's saying he hasn't seen case law to support the claim that Roman made, that these ethical violations indicate a basis for removal and dismissal of Fani from the case. So that's a very interesting little conclusion that he's drawing there, and he's saying, you haven't shown me any case law to show that that's the case. And I have to tell you something, so far he sounds fairly reasonable. I might not agree with his legal conclusion there, but I can respect the fact that a logical argument could be made that it's not a basis for removal.
And then finally, the motions have also evolved to include forensic misconduct on behalf of the district attorney. And again, I don't see how these are a necessary topic for an evidentiary hearing, unless it's made an issue in some way. The public statements, in my mind, speak for themselves, and the application of the law to those statements can be argued. And I don't think any further testimony qualifying them is going to affect the analysis.
So what they're talking about now here is the fact that Fani, and this is a bit of a loss for Roman, this decision from the judge, which should be, I'll tell you right now, I'm expecting that he's probably going to be appealed by Roman on this, that even though he's giving an evidentiary hearing, he's trimming back and saying, okay, so you can't really look into the ethical violations, you can't look into the appointment, and you can't look into the tainting of a potential jury pool. One of the parts that Roman raised in his reply brief was the fact that she made 38 different appearances on TV, is written 2 books where she's publicizing what's going on in the grand jury, which seems to be an ethical violation. And that all of this is, and then she got up and made a speech in church that went on and on and on, where she basically analogized herself to Jesus while asking the Lord to help her with her help his flawed child. So this way she shows some humility here in calling herself a flawed, hard-headed child who's stubbornly going to go forward with this case, while she basically claimed that the only reason that these charges have been brought at all is because she's a black woman and Nathan Wade is a black man. And that's the only reason why any of these charges have been, any of these claims against her have been made, and that she's the persecuted. She's the persecuted one. That's what we're seeing here. She's the persecuted one.
So with that being said, I'll turn it over to Ms. Merchant.
And the judge just said, I don't want to hear any evidence about that. I don't want to have any testimony about that. It does seem as if he may consider it, though. We're not sure. He's basically saying they stand on their own. You don't have to ask her about that. You don't have to have testimony about that. It's possible he will consider that, because it seems like that really could, these public appearances really could have the impact of tainting a potential jury pool. If you assume that a certain percentage of the people there were swayed, have seen her church chat, and were swayed into believing that she's being persecuted because she's just trying to do the right thing here. So in that case, that could be that he will consider it, but he seems to be rather dismissive of it at this juncture.
To you, just at the outset, if you have anything you want to preserve for the record or to reply on, and then from there we can take up the motions one by one.
No, Judge, we appreciate that narrowing issues, and we did plan on being narrow in the evidentiary issues that we were going to be litigating on Friday. As far as those topics, like you said, I think all of those things are already in the record, so we're just planning on arguing those as far as the law. But the evidence we'll get into a little bit deeper with the motions to quash.
All right.
Thank you, Judge.
Okay, so
that was Roman's attorney. It sounds as if they're saying this evidentiary hearing is going to be on Friday. which is bloody annoying for me, but reality is reality. So we got to deal with it.
So let's turn. I didn't really have an idea of the particular order, unless anyone's jumping up and down and says they have another conflict they need to get to. Why don't we start in the order that I received them? So I think the first one we got would have been from Ms. Cross on behalf of the district attorney. And Ms. Cross, the floor is yours.
Thank you, Judge McAfee. I appreciate the narrowing of the issues. I think that the state's motions to quash all relate to the areas that you consider to be available and open, so would be potentially still be the subject of any evidentiary hearing held this week. I think
this is Fani Willis's attorney talking now.
From the state's perspective, and as the court is aware, Ms. Merchant has subpoenaed a total of 9 employees of the district attorney's office, including the district attorney herself. Those range from the opposing counsel on the prosecution team prosecuting Mr. Defendant Roman, current and former members of that team. It includes individuals who have no direct relation with the prosecution, but also no relevant information, including the district attorney's personal executive assistant, members of her security detail, and other individuals who are employed by the office and quite outside the area that the court has determined to be of relevance in any future evidentiary hearing. The state's position is, and I think the evidence is clear, that these witnesses who Ms. Merchant or no opposing counsel has ever spoken to cannot be in good faith represented to the court as having information that would be relevant to any of the individual issues that the court has identified to being of interest. These witnesses, again, have never been spoken to, and nor Ms. Merchant nor anyone else can represent what they would say. I will represent, however, what they would say. They would not in any way support the wild speculation that was included in this motion.
If they're talking about drivers and people like that, they would, if they saw the questions about what they saw. Well, let's hear it about what they saw them, how they saw them interacting with each other, where it is that her driver was driving her home, her security detail, where it is that they were dropping her off, whether or not that's where Nathan Wade was staying. You would think that that would be highly relevant, but they're obviously going to make the claim that, and her testimony right now, or her, it's not even testimony, her claims about what they would say seem speculative, but we'll see what the judge says.
It would not support, as was raised in the reply brief that was filed this morning. Ms. Merchant represented that these witnesses subpoenaed, I think 2 weeks ago now, prior to the filing of Mr. Wade's affidavit, that any of these witnesses would refute the allegations or the representations that were made in the Wade affidavit. The allegations and the speculation from Mr. Roman's initial motion has been, I think, is clear to the court now. There have been several representations that were made that were not true, were not in good faith, could not be supported.
How do we know this?
These witnesses that have been subpoenaed now for a hearing this afternoon have nothing at all to add to the allegations that were made, nothing in support, nothing that would undermine the affirmations that were made in the Wade affidavit. The affirmations and the facts.
These self-serving claims that the attorney are making now seem fairly weak. And the reason they seem weak at the outset, we'll see what the judge has to say about them, is there's no testimony about what they would say. She doesn't know. Did she talk to them herself? Like, how do we know that what she's saying is true?
Sworn by an officer of the court that were made are categorically true. They're 100% true. And there's no witness, certainly none of the 9 that were subpoenaed, that are representative of the district attorney's office that will say otherwise. We've pointed out to the court all of the law that disfavors a defendant or any litigant subpoenaing opposing counsel or members of the opposing counsel's litigation team. A criminal defendant does not have the right to make claims without admissible evidence and then subpoena the other side in an effort to conjure up some evidence to support them.
Yeah, but the judge already said that there is admissible evidence in the form that Wade already admitted there's a personal relationship. So that's what gives us the legs here to actually look further.
That's not serious. That's an abuse of the subpoena power.
This is a weak argument because of the fact that they have this admission. You're saying there's no valid evidence to support these claims. Well, we have Wade's admission, and we don't know where he was, which parts he was omitting.
It's the defendant's burden, now that the motion to quash has been filed, to establish the relevancy. And the state believes that there's just no way to make that claim in good faith, given the record that's before the court now.
The judge already disagreed with you on that.
Let me phrase it this way. This is a
Sorry.
serious case. These are serious charges. Your Honor has been running a serious courtroom. And in response to the accusations that were made, the state presented the court with law that establishes that even if all of the allegations were true, and they're not, that is not a basis to either dismiss the indictment or disqualify the district attorney's office. The state has brought you the law. The state has brought you facts in the form of a sworn affidavit from the officer of the court, identifying the timeline of the relationship, the facts as it relates to any financial involvement related to the allegations that were made. There is no personal interest on behalf of the district attorney or her office in the prosecution of this defendant. And there is no financial interest in the prosecution or conviction of this defendant by the district attorney's office. The travel that was taken, as represented in the affidavit, was roughly equally divided between the two of them in terms of responsibility.
That's certainly not accurate either. That's a very poor portrayal. He paid for like 4 trips and she paid for 1. He laid out like over 10 grand. She laid out like under 1,000.
And there's no evidence that can be brought that would dispute that. These are serious charges. The state has responded to them seriously. And I think the court's action here will be informed by the other motions to quash that you'll hear this afternoon. My understanding is that of all of the witnesses subpoenaed, there will be no individual who has relevant information that would dispute the affirmations in the Wade indictment.
That's exactly.
The defense is not bringing you facts.
This is a trust.
The defense is not bringing you law. The defense is bringing you gossip. And the state cannot, and the court should not, condone that practice.
Here.
I understand the court's representation.
Amen.
I understand the court's position that an evidentiary hearing is required. If that is required, none of the witnesses identified here in the state's motion are properly subject to subpoena. And so that's addressing the employees of the district attorney's office and the district attorney. The state also filed a motion to quash the subpoena to Mr. Bradley, I believe is his name. Mr. Bradley is someone who was a former business partner of, thank you.
Bradley was specifically identified in the reply papers from Roman that we reviewed yesterday. And in those reply papers, he informed the defense counsel that their relationship preceded the hiring of Wade as special prosecutor.
Former business partner of Mr. Wade. He was also his attorney related to divorce and domestic matters. And that relationship began in 2015.
Now, this is a very interesting thing here, because one of the things that I'm sure we're going to hear a lot more about Bradley's relationship with Nathan Wade. He was his attorney at one point, but Roman argued in his reply papers that the attorney-client relationship between Wade and Roman only began after he had been hired as special prosecutor. So that his testimony about what preceded the nature of the relationship prior to the hiring of Wade as prosecutor was not governed by attorney-client privilege. If it were governed by attorney-client privilege, in that case, you can understand the court granting the application to quash the subpoena, saying, I'm not going to get him up here on the stand and say attorney-client privilege on every question you ask. So this is an important element that we should anticipate the judge is going to address during the course of this hearing.
2015 FAR.
And it's very important because he seems to be the one person who went on record as saying that this relationship predates his hiring, and without him, it's hard to imagine how Roman will be successful.
Predates any allegation relevant to the motions. That attorney-client representation continued through and including, I believe, 2022.
Even if he was his attorney, it depends on the nature of how he was his attorney. In other words, at one point, I believe he got involved in divorce proceedings, in which case the nature relationship with Fani might be relevant in that context. But if he's his contract attorney or some other attorney, trademark attorney, whatever type of attorney it was, that has nothing to do with his relationship with Fani Wade, he doesn't become a divorce counsel until afterward. In that case, he is not retained for that purpose. In that case, just two friends talking. And there would be no attorney-client privilege that gets implicated. I expect to hear the judge go through this analysis.
There has been no waiver of privilege of that, and I believe that the evidence or the record before the court would demonstrate that defense counsel knows that this relationship, attorney-client relationship, exists, that she knows there will be a privilege invoked, and that it just is designed to obtain more public relations, more spectacle, and that the subpoena to Mr. Bradley should likewise be quashed. I believe Mr. Evans, if he's here now, will address in more detail the bank records, but given the court's representation, I won't go into that. I believe if that.
I mean, you might be thinking this, and I want to clarify this. You're all on the same page here, okay? If I have a client and he starts talking to me about some personal thing that has nothing to do with my representation, because he and I have established a personal relationship, that is not governed by attorney-client privilege. There's no such concept as expectation of privacy, because it's about a personal thing. So if I have a client who hires me to represent him in some commercial litigation, he's in a business dispute with someone, and he starts talking to me about the fact that he was diagnosed with some sort of disease, that's not governed by attorney-client privilege.
Was included, please correct me if I'm wrong, but insofar as the subpoena has been issued for the bank records of Mr. Wade and his law practice personally and other entities associated with him, that's clearly a fishing expedition that the law does not permit. Yes, the court to quash that is overbroad and harassing.
All right. I think there's a lot to take up there. Ms. Merchant, why don't I let you respond generally, and maybe we'll descend into the particulars afterward.
Great. Thank you so much, Judge. Judge, a couple things on the state's response or the state's argument to quash, Judge. First, I'd just like to point out the state is asking that this sworn affidavit from an officer of the court, from Mr. Wade, be considered. But when we were in federal court, Ms. Cross argued that an affidavit is not admissible. We don't believe an affidavit is admissible in this case. You can cherry pick in an affidavit what you want to talk about, and there's no cross-examination. So that is not, it's not admissible. We put that in our brief. We've argued that it's just not admissible. It's not relevant. It's hearsay. It's nothing more than hearsay. We have a right to make a record on these allegations. And as long as we keep our evidence and our questions narrowly tailored to that inquiry, that is our right. We have a right to explore whether or not there was a...
And she's right. It is technically hearsay because it's an out-of-court statement. It's not being made in court. And that's the first words with respect to defining hearsay, an out-of-court statement that's being offered for the purposes of establishing the truth of the matter asserted therein. So if it's an out-of-court statement, it's hearsay. Even if it's sworn under oath, it's hearsay. So she's right. And the reason why it's hearsay is for the reasons that she aptly pointed out just now. He can't be cross-examined. And more importantly, he can cherry pick. He can say, he can be very precise in swearing to something that would be truthful and purposefully omitting things that are damaging to his position. So we don't know anything about the stuff, anything that he decides personally to omit. And he's obviously going to omit stuff that's potentially harmful to him. So that form of cherry picking does seem as if this should be inadmissible for purposes of an evidentiary hearing.
Personal or financial benefit to Miss Willis from this relationship. And we have carefully chosen the witnesses that we have subpoenaed based on that. And I just want to walk through a couple of them. But before I do, before I move on the affidavit issue, Mr. Wade has filed other affidavits in his divorce case, which contradict this affidavit. His interrogatories, which were sworn and verified and filed in that case, said that he did not have a personal relationship.
The man a liar. He's a liar. Wow. Yeah. The state's going to lose on this application, I think. I'd be very surprised if they win this application. Very disappointed in the judge if they do.
That there had been none. So we've got two declarations in two different courts, both sworn, both filed with the court, that say something completely different. His May 2023 affidavit, where he was asked if he had, and this was in 2023, Judge. So the state's response last week said they had a relationship that began in 2022. In May of 2023, he filed in the Cobb County Superior Court a pleading that said specifically if he had had any relations with a person other than his spouse during the course of the marriage, and the typical things that are asked in a divorce case, and he responded none. After we filed our motion in this case, he updated those and he pled privilege under the Fifth Amendment. So we've got a filing under oath by Mr. Wade in 2023 stating he didn't have a relationship. Then we've got a filing stating he did have one starting in 2022. And then once that came about, he fixes the incorrect affidavit that was filed back in 2023. So we definitely have a conflict, Judge, in the evidence as far as when this relationship started. Just from the hearsay affidavits, we've got a conflict, Judge. There's also some other things in the Wade affidavit that we have conflicts in. We've got the date. We've got whether or not they cohabitated, whether or not there were any funds that he was paid, that he used for travel with Miss Willis. We have quite a few documentations that we have attached to filings, and we have more that we intend to present at the hearing in this case to show that she did receive a lot of benefit, a lot of financial benefit in the forms of different trips, plane tickets, hotel rooms, Ubers, dinners, things like that. We have all of those from the financial records, which I'll go into in just a minute to stay on task. I'll go into those in just a minute. But that's as far as Wade, why we think that Wade definitely should be called as a witness in this case. How can Mr. Wade not have relevant information to this inquiry? That is the real question here. He probably has the most relevant information to this inquiry. Same as Miss Willis. She probably has the most relevant information to this inquiry. Mr. Bradley, the state has taken it upon themselves to file a motion to quash Mr. Bradley's subpoena. Mr. Bradley has not filed a motion to quash. The divorce in this case was not filed until.
Oh, I was sorry. I didn't realize I was muted. I apologize. What I said was Wade is almost certainly going to be compelled to testify. It will be interesting to see if the judge gives him a chance to crack Fani as well. So not really. I expect that they will get a crack at Fani.
Until November 2021. The only privilege that can be asserted is things that were said in furtherance of legal advice. So if Mr. Wade made statements or comments to Mr. Bradley in furtherance of legal advice, we're not going into any of that. We don't have any intention of getting into a privilege dispute, what was privileged and what was not. The relevant information that Mr. Bradley has to this inquiry is that this relationship started prior to Mr. Wade being appointed as the special prosecutor in this case. He has firsthand knowledge that this relationship predated that. He has knowledge, and not privileged knowledge, Judge. The divorce action hadn't even been filed at that point. He has personal knowledge, not privileged knowledge, that they had cohabitated, had stayed at the same place. And, I certainly don't intend on getting into an argument over what the term cohabitated means. They had stayed together. Mr. Wade had stayed at places that Fulton County was paying for Miss Willis to stay at. He's got information about that. We have outlined all that. We've made a proffer. That is not privileged information, Judge.
And unlike some of the, I guess, other witnesses that are here challenging their subpoenas, my inference from the supplemental reply is that this is something that you have corresponded or communicated with Mr. Bradley about directly.
Yes, only non-privileged information. Yes, Judge.
All right. And so let's put the district attorney and Mr. Wade in a separate category. I think you would still, now that the motion has been filed, need to make some kind of showing for the other 7 witnesses challenged by the state.
So it feels like they're gonna be able to drill Fani and Wade, and he's putting them aside because he's like, yeah, I'm gonna have a hard time keeping them off of the stand, but yeah, I'm gonna let you. I'm gonna let you. He hasn't made an official ruling on it, but it sounds like at this point he's leaning towards saying that I'm gonna let you inspect anything that came out of Fani or Wade. Is the cult tax exempt? I'm not a tax attorney, but you would think so. We need a pallet of butter on stick. We need a pallet of butter on stick, Lizzo, last night, plus the tractor fuel. I'll email you the receipts to you later. I'm not the government, but I would think that you definitely should consider any expenses in unsticking Lizzo. That certainly you would think it would qualify. I mean, that's part of the job. Part of the job.
And Judge, sometimes when we subpoena witnesses, if they would be fallback witnesses, for example, if you don't force Miss Willis to take the stand, then we would have to present witnesses to establish what Miss Willis could be questioned about. And so some of those witnesses would be cumulative of what Miss Willis testified, but they could be impeachment. It just depends. And so I'll go through all of those witnesses, Judge, as far as our belief that they have personal information. How I sort of categorize
what
them.
the judge is forcing her to do at this juncture is explain to me why this is not just a random list of prosecutors, but why you think these specific people will be able to provide insight about the nature and timing of the relationship between Fani and Wade.
We had Willis, Sonia Allen, and Dexter Bond, and then Daisha Young. So Sonia Allen is the head of the anti-corruption unit. She's the one that essentially started these contracts for all of these anti-corruption contracts, which is where most of the outside counsel work in the DA's office is coming from. She has personal knowledge about the relationship between those parties, about the financial benefit, about the contracts. She's the one that is the head of the anti-corruption unit. And, just to focus in on whether or not we have to talk to a witness before we subpoena that witness, there's no law that says you have to talk to a witness before you subpoena them. And that makes sense. Police officers regularly do investigations and they talk to tons of witnesses. You talk to one witness and it leads you to another witness, and you subpoena people who are not particularly willing to talk to you. I asked all of these people to talk to me. It's not surprising that they don't want to. They also all have NDAs. So they have non-disclosure agreements that they've been asked to sign by the district attorney's office. And so they're hesitant. And I'm not saying these in particular, but members of the district attorney's staff are hesitant to talk because of that.
Now, this is an interesting point she's raised about NDAs. NDA is lawyers speak for non-disclosure agreement, which means that they're not legally allowed to talk. Almost every non-disclosure agreement that's out there will have exceptions to the non-disclosure agreement. And one of the first exceptions that are granted typically are if you're being compelled by a court to discuss matters that you're not allowed to disclose. Well, in that case, the non-disclosure, that would not, and you disclose it there, that would not be considered a violation of non-disclosure agreement. So what Merchant is arguing here is, yeah, if I go and try and get these people to talk to me, they likely have signed an NDA that they cannot, and that precludes them from talking to me. But if we put them on the stand, in that case, those NDAs will likely not apply anymore because that will be one of the exceptions to the non-disclosure agreement.
But a court order, such as a subpoena, would alleviate any of those concerns.
So recognizing that, even if you don't have to talk to them, I think you would still have to have some kind of good faith belief of what it is they could possibly say that is relevant, or that you could later impeach them on that then becomes substantive evidence, right?
Right.
So what is it? Let's just start with Miss Allen. She
Okay.
starts the anti-corruption unit. She may have been there at the formation of these contracts, but is there anything as part of that you think plays into these issues?
Just personal knowledge as to when the relationship started. These witnesses would all have personal knowledge as to when the relationship started.
And when we say the relationship, are we referring to just the fact that they knew each other, or that they knew that it changed or evolved?
That it was that the relationship predated Mr. Wade being hired as special
Evolved.
counsel.
Say evolved.
And what aspect of the relationship?
That their relationship was romantic, Judge. I'm sorry. I should have been more specific.
Sure.
So these witnesses all have personal knowledge. And I've talked to a lot of different witnesses, and a lot of witnesses, when you're investigating a case, some witness may not have personal knowledge, but they might know someone who does have personal knowledge, things like that.
Understood. How do you know Miss Allen has personal knowledge of that?
From Mr. Bradley.
Okay. All right. And so theoretically, if Miss Allen testified and denied that, Mr. Bradley would be able to impeach her?
Right. Yes,
Okay.
Judge.
All right.
And the same with the other witnesses, Ms. Young and Mr. Bond. Yes.
The same argument. Nothing else to supplement that or to add?
No, not for those, Judge. There's a couple other witnesses that we included. One of them is so Robin Yurdy, who we'll get to in a minute, was Ms. Willis's executive assistant. I subpoenaed her current executive assistant, which is Tia Green. That's her personal assistant who keeps her calendars, does all of her scheduling. She can testify as to travel that they took together, spending, different information about spending, and then also the personal nature of the relationship. And then all of the other folks are.
Well, we're moving on. So that was Allen and Young. You'd lumped Bond into that same initial category. So what about him?
Yes, I did. I'm sorry, Judge. I lumped Bond, Young, and Allen into that same. Basically, I lumped the lawyers, Willis, Young, Allen, Bond, and Wade, all together as far as personal knowledge of when the relationship began.
And although, again, just focusing on Allen, Bond, and Young, although you're saying you don't personally have statements from them on the record or in some kind of documentary form, you're saying that if they deny knowledge, you have someone who can impeach that testimony.
Yes, Judge.
All right. Okay, let's move on to the next category, if you've got one.
Tia Green, that's the executive assistant. And I'm sorry, I jumped ahead on that argument. Ms. Green replaced Robin Yurdy, who is the former executive assistant, essentially does calendaring, keeps calendars, things like that, and can attest to when travel was made. Some of the things we've got travel documents that we have to admit in other areas, but this would put Ms. Willis with Mr. Wade on these trips.
And again, we don't know what Miss Green would say.
Right.
So is it just the fact that she keeps the calendar that you assume she knows that she's going with Mr. Wade?
Right. Well, that she knows that she keeps the calendar. She's her personal assistant. And so Miss Yurdy did that before, and Miss Green took over that job.
But other than saying, it's possible Miss Green could just be saying, yes, she was out of the office this week, and that's all I know about it.
It's possible she could say that. Yes, Judge.
And do you have any evidence to suggest she knows more than that?
Not specifically, no. And she has unfortunately not been willing to talk to me.
Understood. So that seems that like there's less there for you to work with.
There's definitely less there for me to work with. Yes.
What else do you think I got to know about Miss Green then?
With Miss Green, it's really, so Miss Yurdy was the one who had this type of relationship before, and Miss Green took over that role, that personal assistant role. And my investigations revealed how Miss Yurdy knew all of the travel arrangements, purchasing, things like that. And that's what led me to Miss Green.
Okay. All right.
So the other area, all of the other folks for the DA's office are people in security, essentially, investigations and security. They are people who have served as the personal detail for Miss
This would
Willis.
be Hill, Green, and Hicks.
Unfortunate.
Right?
Yes, Hill, Green, and Ricks.
Hold your focus. Hold your focus.
And those folks have served as Miss Willis's, she calls them the head of dignitary services. It's essentially the team that follows her around and takes her places. And they would be able to testify, from the witnesses I've talked to, they would be able to testify about she and Nathan going to the safe house together, living at the safe house together, staying there regularly, things like that. cohabitating essentially, which disputes what is in the affidavit.
But I guess if you're referring to maybe a specific date or time frame, you don't know which of these three witnesses, if any of them, might personally know about that time frame or could.
I believe all three of them do. I believe
Okay.
all three of them know about that. I've spoken with other.
And this way they can, you have three people impeaching him instead of just one. That's relevant too. I mean, so what? Even if they're going to say the same thing or relatively the same thing, the fact is it's three people contradicting Wade, which that's important in a he said, she said, right? If the DA's office is kicked, is there a chance for review, dismissal of the entire case by a state attorney or some other party? It seems unlikely. It seems, I'd question exactly how they would do it. It's an interesting, I was thinking the same thing. Like, could they turn this over to the federal office? I don't know. I wouldn't know how the procedure would work. I'm sure that that's not something that happens very often. So I think you're asking a fair question. I don't want to jump in with an answer because I think it would be highly speculative on my part to do so.
There are people who were formerly on the dignitary services who did not do that and who identified who are the ones that actually would have that direct knowledge, actually did the transport of Ms. Willis and Mr. Wade.
And so if either of these individuals came and denied having any knowledge whatsoever, you have someone who could impeach them having made a prior statement explicitly on that point?
Yes, I do.
All right, what else?
I think the only other issue for the district attorney's office was the bank records. I don't know if you wanted me to go ahead and go into that now or wait for Mr. Evans to talk about that. The state had.
Right. No, I think we'd want to loop him in on that. But let me just, on this first issue, allow Ms. Cross to jump back in. And so, Ms. Cross, focusing solely on whether defense counsel has made a good faith basis to show that the relevance of these witnesses, even though, she may not have talked to him or they didn't want to talk to her, why is quash still appropriate?
Quash is still appropriate here because even Ms. Merchant's recitation to the court of the facts and circumstances of why these witnesses are relevant displays a misunderstanding of the role of these individuals and in particular the role of Ms. Yurdi. Ms. Yurdi was never part of the executive staff or team. Ms. Yurdi was not someone who kept the district attorney's schedule or calendar.
In my opinion, it feels like Anna Cross is flailing. It's like she doesn't really have much of an argument with respect to the other districts, the other members of the DA's staff. And now she's focusing exclusively on Yurdi and saying, aha, I gotcha on one technical element to her role. Well, I think she mentioned that Yurdi has a personal relationship with Ms. Wade, which one would think would put her in a position to have knowledge as to her as to her when she got a boyfriend.
The allegations here are she worked on the media team was her role. The media team, not the executive staff or team or responsible for calendaring the district attorney's office.
But just to be clear, I mean, your motion doesn't cover Ms. Yurdi. That's
it doesn't. It doesn't.
But you're saying that impacts the argument towards Ms. Green. Okay.
Correct.
All right.
Correct. And the other individuals, Ms. Merchant didn't make a representation to the court about how Mr. Bradley would know about the knowledge of Ms. Allen,
He told them that he knew. These are please help me judge arguments.
Bond and Ms. Young. That is, I think, relevant information. If it's not admissible, any impeachment evidence she has would not be admissible. Likewise, the security.
Why wouldn't it be admissible?
That's what I was wondering.
If Mr. Bradley heard that second or third hand that Ms. Allen knew this, or Ms. Young was aware of that, or Mr. Bond said this to someone else.
You're saying it would be hearsay, but that's not what they're claiming.
Right.
That wasn't the impression I got. The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about specifically?
Well, essentially, that kind of seemed to be
confessions.
All of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
All right, Ms. Cross.
I
don't like Bradley.
will be shocked.
Yeah, that's not a motion. That's not a basis to quash. The fact that Anna Cross would be surprised is not a reason to grant the motion. I'd be surprised if they testify. Oh, well, maybe you'll be surprised. We don't know.
If Ms. Merchant is able to support that statement.
This is flailing. This is flailing. Oh my God.
Shocked. I don't believe that's true. I don't believe, even if it was true, and it's not. And can I just say, when we're talking about the timeline and what might be relevant in an evidentiary hearing, there is, I guess we could spend a lot of time talking about dates and timelines and who is responsible. But for the record, and should there be an evidentiary hearing, I understand the court's ruling, there's an evidentiary hearing. What the state will establish with unequivocally is that there was no cohabitation. District Attorney Willis and Nathan Wade never lived together, that the representations that have been made to date are just demonstratively untrue.
Wow. This seems like it's not going to take very long to get to the bottom of this. You wouldn't think this will take very long to establish if what you're saying is true. But I'll tell you, she sounds like right now, I mean, that's not, even if she was 100% right what she's saying, all right, so we need evidence about this. There's definitely he said, she said here. That's why you have testimony. That's not a basis to quash testimony. That's why we need the testimony. She seems like she's like 15 seconds from saying, "Excuse me, Judge, can I have a moment?" And then you just hear door slamming and just sort of like this whole like running down a hallway, and then you hear she wants out of here. She wants out of here because her motion to quash is dying.
For example, the allegation is that they lived together in District Attorney Willis's home prior to District Attorney Willis's father living with her, and that when the father moved in, then Mr. Wade moved out. Of course, that is untrue, and the state would be able to establish that Mr. Floyd, District Attorney's father, moved in, even changed his Georgia driver's license prior to the time that the District Attorney and Mr. Wade ever met. That
Let's check
the
it out.
testimony from Mr. Floyd would be that he lived there continuously and never saw Mr. Wade there.
Well, we'll see that.
The evidence would be that the timeline that's being represented is either mistaken, if that's charitably, or simply fabricated. So I just want the court to understand that this is the hearing that we're contemplating.
Are you testifying? That's not the nature of what's supposed to be happening here. You're supposed to be saying that you're supposed to be arguing. An effective argument here would be something that's trying to go to the point and saying that for one reason or another, all the bases that were laid out by Ashley Merchant do not create relevance, not refuting what they would say. You don't know for sure what they're going to say. You can't testify about what they're going to say. If you could, it would be hearsay.
I understand the rulings. But to return to your question about Ms. Allen, Mr. Bond, and Ms. Young, I believe that the spectacle of calling opposing counsel to, in this case, deny that they have any knowledge about a relationship, because they didn't have any knowledge about a relationship, and certainly none that contradicts the Wade affidavit. Calling them in to say that, and then another individual to say, no, I heard otherwise,
It's embarrassing.
appears to have very little evidentiary value. I will put it that way. Even if the good faith basis that Ms. Merchant represents has very little evidentiary value. Insofar as
I'm going to tell you why she's a failure, this woman. Okay, and why she's being a complete failure right now. What she should be arguing is this. She should be arguing, we already have the affidavit from Mr. Wade. None of these people have any evidence which can support that. And that this is an effort by the defendants to try and sidetrack and derail the timely execution, the timely implementation of justice that the state is trying to impart, and just justifying this hearing and giving it any sort of credibility only is only designed to create a bogus scandal here, which puts the district attorney's office in unwarranted disrepute. And that's the argument she should be making if she were effective counsel. I don't think she expected there to be an evidentiary hearing. I think she assumed that the judge was going to rule on their side completely, and that there are going to be certain things that the judge wants to explore further. So that's why I think she wasn't prepared for this argument. But if she were prepared for this argument, that's the argument she should be making. That not only are there salacious arguments, self-serving fabrications, but by entertaining them, you're giving credibility to something that is completely fictional. And that's what she should be arguing if she wants to be effective counsel. She's not making that argument, though. Instead, she's like, no, that's not true. No, it's not true. That's testifying. That's not a legal argument.
As the security staff was referenced and mentioned. Again, I don't believe that there is a good faith basis to believe for any witness to say that the two cohabitated, they never did so. I don't believe there's a good faith basis for any witness to say that there was a relationship prior to 2022, as was represented in the affidavit. These witnesses who have a host of other security sensitive information about the district attorney and her travels and her arrangements and the means by which she is kept safe under the constant threat that I think we all recognize is there, that there is no good faith basis to believe that they have any information. Again, she's never spoken to anyone, and I didn't hear a representation that anyone could impeach those witnesses with testimony that they said otherwise. So I think those are properly quashed even without further inquiry.
In that last bit, you're referring to the investigators?
Yes, sir.
Well, I mean, again, I think that's what Ms. Merchant is putting out here, that her star witness, Mr. Bradley, is able to impeach every one of them. Is that what?
I didn't hear the representation that Ms. Merchant said that Mr. Bradley told her that he has personal knowledge that investigators Hill, Green, and Ricks had knowledge of a cohabitation or a personal relationship prior to 2022.
Ms. Merchant?
Maybe I missed it.
It depends on your definition, Judge, of cohabitation, that they stayed at the same house together, slept at the same house. Yes, that they have knowledge of that.
And again, knowledge based on statements that they made to someone else who you do have under subpoena and will you would intend to have testified at the hearing.
Yes, and Judge, just for background, when DA Willis took office.
This is not in front of a jury. This is all in front of a judge who's making illegal findings here as to whether or not to quash these motions. So, she's not really. This is not considered play preach to the court of public opinion, because how are they going to make their arguments? This is a matter of the public being able to see what the arguments are, and I'm grateful that they air these. So we all should be.
Yes, Mr. Bradley had a contract. So did Mr. Campbell. They all had contracts. The whole firm. They were three partners. It was Bradley, Wade, Campbell, a 3-person firm. They all three had contracts to work at the DA's office. So they're all working at the DA's office in some capacity. 2 of them had these taint contracts. So Bradley had 2 contracts, actually. He had a first appearance contract. So did Mr. Campbell, and Mr. Bradley and Mr. Campbell also had these taint attorney contracts where they're working directly for the unit. So it's not just this lawyer that he's partners with out in Cobb County. They're all together. They're all intimately together.
I mean, that's good by way of background, but really, I just think just to get over that threshold today, and Ms. Cross, I'll let you have the last word here, but I don't know how many times, or you may have argued at a closing the pattern instruction that a single witness, if believed, can establish a fact. What I'm hearing is again emphasizing the conflict in the evidence, and if the state it sounds quite confident that it's going to have an abundance of evidence to show these things are not true at the hearing, but I don't see how I can make that determination on the front end without live testimony subject to cross-examination and an assessment of demeanor and everything else that goes into those kind of determinations.
What he's saying is you're making factual arguments. That's what he just said in fancy judge language. You're making factual arguments, not legal arguments. And if it's a factual argument and you're saying all the facts are on our side, well, in that case, let's bring everyone in here have them testify, and then I'll determine their credibility and whether I believe them or not. But that's not an argument to say that they shouldn't come in here, which is what you're supposed to be arguing about. That's essentially what he's saying to Anna Cross right now.
I don't see a way around that. Any final thoughts for me?
Only, Your Honor, that
We will.
I'd ask the court to
The South will rise again.
hold or reserve ruling on the state's motion to quash until Mr. Bradley, who appears to be the sole and primary source for the allegations that have been made, until he testifies at a hearing. And then if you're not otherwise inclined to quash the subpoenas, that they be revisited at that time.
All right, I think that is appropriate. So to that end, one thing I would share is that obviously, as we've talked about, the rules of evidence would apply, but this is much more so than I would do in front of a jury. I plan to be proactive about the application of 403 and 611. And so if there's anything that...
Right. And that's 403 is hearsay and 611 is...
It's cumulative. If there's anything that is referring to, as in the words of the rule, harassment or undue embarrassment, I'm not going to feel inhibited from stepping in, even without an objection from counsel, to move this along and keep it focused on the issues at hand. So to that end, I do think that, again, under the court's authority to control the order and manner of presentation of the evidence, it would be important that from the outset, we're not talking about calling Ms. Willis as the first witness, and we need to get over a few procedural hurdles before we can get there. So I agree with Ms. Cross on that point. So, however, when it comes to the issue at hand, I think Ms. Merchant
Oh, I apologize. I misspoke. 403 is relevance, by the way.
has established a good faith basis for relevance, and I don't see how quashal can be imposed here. I think it's a closer
Nice.
call with Ms. Green. That may yet result in quashal, but at this point, with each one of these witnesses, I would defer the ruling until we get further into the hearing itself. All right. Anything else, Ms. Cross? I know you had also talked about the bank records, and as it relates to privilege issues with Mr. Bradley, I think those just need to be handled as the questions are put to him. And if it needs to go into an in-camera session, we can do that. But it sounds like Ms. Merchant is aware of that issue. We would need to establish when and how and the scope of his representation of Mr. Wade. And we could proceed very carefully to make sure that issues of privilege are not gone into.
Thank you, Your Honor. We, of course, Mr. Evans will speak to the bank records insofar as there is a privilege. Again, Mr. Wade does not waive any portion of it. And if that could be a conversation that takes place in chambers as opposed to in open court, I think that would be beneficial for everyone.
All right. Let me turn then to Mr. Evans. I think it did join us by Zoom now. And
can you hear me, Your Honor?
I can, there's a bit of an echo. Give us a few more.
We jumped in a
Is that
little
better?
Surely.
That's much better. All right. So having reviewed your motion to quash and the reply, and with the benefit of what you've just heard before, my remaining concern deals with scope and overbreadth. I think the subpoena is pretty broad there. So maybe we could start with that, Mr. Evans. Anything else you'd like to add?
Yes, thank you, Your Honor. The scope is not just overly broad, it's limitless. It requests any and all documents in Synovus Bank's possession related to Nathan J. Wade, Nathan J. Wade PC, Nathan J. Wade PC, and or Wade, Bradley, and Campbell law firm.
Well, they can limit it certainly as to time. Put it back within the last 3 years or so. And that would be a significant limitation.
So there's no dates given,
Yeah, dates are important.
no scope is provided.
Scope is less relevant, but okay. I guess it would have to be bank records, not, let's say, like if they're holding securities and things of that nature, which is no allegation that he was using his portfolio to finance his relationship. but I would think it would be bank records.
No reason requesting these documents is mentioned, and no connection to the criminal charges against Roman is cited.
And yeah, he is frozen. He's frozen for the court as well.
So you mentioned a reply. I have not seen any reply filed.
I didn't file one on his.
Okay. I suppose it didn't relate to your specific motion to quash. Let me just start right there. There's no date range whatsoever in this, Ms. Merchant. Why is that not quashable just on itself?
Judge, and if there's no date range, then we were supposed to have certain records. So I've already received most of the bank records. I need a business record certificate, which is what I sent with the subpoena, because I cannot admit those records at a hearing without that business record certificate. The records I have end in November, I believe. They're voluminous. And I wanted to be able to do a summary under 1006 for the court, because I agree, I don't want to go into tons of bank records. I don't think, 98% of them aren't relevant, but 2% are. And so in order to get them into evidence, I've got to have a business record certificate. I had to subpoena the banks to get that business record certificate. I've got the documents I've got a business record certificate that was filed in the divorce case, but I don't have one for this case. So, and the one that was filed in the divorce, or the one that was received in the divorce case, I believe ended in November, those records. So that's why we need these.
So the only thing you're after still, you're saying is for Synovus Bank to have signed a certification.
Yes, Judge.
All right. So just a kind of a sub issue here.
It is great comedy, Denise.
What authority do you have that someone can be subpoenaed and forced to authenticate a document?
They can't be forced to authenticate the documents so that they authenticated in the Cobb County case. And it's
Or even the ones they produced. Well, they haven't produced any in response to this, right?
no, they have not.
You're saying you've got what you need already from the Cobb County case.
Right.
And you need a further record certification for what exactly?
So I have the records that were submitted under the business record certificate in the Cobb County case. That's a civil case, so it's a little bit different rules, but not major different rules because of business records. So I've got that business record certificate. They certified those records. I've got that. But I wanted one for this case, a business record certificate for this case. So that
You just want a different case number on the business record
well,
certification.
it's the same records. I mean, I did not anticipate this would be a big deal.
Why do they need a different case number? Why wouldn't a business record certification for another case apply in this one?
I was just being overly cautious to try and get it because I anticipated an objection to that because they were certified in that case. If there's no issue with that, then I've got the business record certificate.
Well, I won't rule on it proactively unless I see whether there's an objection from the other side and what argument they have on it, and that would be up to the state. But to the original point, even if you've subpoenaed someone for a business record certification, is that an appropriate use of a subpoena?
I would bring them here to get the records, because if I don't have the business record certificate, then they have to take the stand and I get them in
Sure.
that way. So that's why I subpoenaed them.
So the bank itself is a person has acknowledged subpoena from the bank.
Yes. I talked with the bank. The bank actually has a lawyer, and they don't want to come to court. They want to submit a business record certificate.
All right.
And I don't have any problem with that. Like I told them, I just need that in advance of the hearing so I can put the state on notice of.
All right, Mr. Evans, having seen that the scope of your motion to quash is very much a more narrow focus than perhaps we thought, any reaction?
Well, Synovus refused to produce the records pending the motion to quash. So I don't know about they haven't agreed to produce anything, but what is the purpose of trying to get the personal and law firm bank records? What is the goal here?
Sure.
That's part of what's overly broad about this is not just that there's no dates, not just that there's no scope, but there's no connection to the underlying crimes charged against Roman, neither alleged nor could there be. What are we hoping to even discover here? Number one, how would that be relevant? Number two, and just what is the general purpose of all this? I mean, keep in mind this subpoena went to Synovus.
The purpose of a subpoena is rarely is an odd thing for the recipient of a subpoena to be arguing about. Usually, it's not their business what the purpose is. but perhaps the court will entertain that. It's a very strange thing to be arguing. To say it's too broad, yeah. But, I mean, the purpose, I mean, why is it your business? I guess they're saying relevance. I guess it's a relevance argument.
Never went to my client. Ms. Merchant hid it from my client. We only knew about this because Synovus properly and timely alerted us of the subpoena. So all of this was meant to be kept outside of our knowledge. So it's done in secret. It's done in a way that has no limit whatsoever on it, and it's done with no reason mentioned. So what is the goal here?
Sure. Okay, Mr. Evans. And so I'm clear, the subpoena is not just the law firm records, it's also Mr. Wade's personal bank account records. Is that right, Ms. Merchant?
Personal bank account records at Synovus. It's law firm records.
Okay. So other than maybe showing or proving how much money the law firm received as a result of the representation, why do we need these?
It's not that. He actually paid for most of the trips out of the law firm money. Okay. So that's why. He paid for personal trips that he and Ms. Willis took using law firm money. And there's quite a few different bank accounts, which is why I don't mean to sound vague. It's just there's a couple different bank accounts, and I have all of the bank records, and we put a lot of that in our motion, our response, so that the court would have some specifics as to the money that was spent. But essentially, the money's being spent on Ms. Willis. Some of the money is being spent on Ms. Willis. And so it's relevant to show that she has a personal or financial interest, which is the entire issue of disqualification. So the hearing that we subpoenaed these records for has nothing to do with the guilt or innocence of Mr. Roman.
Well, you don't have to address that.
Okay.
But I guess going back to the core point here, the subpoena at issue did not have any limitation on time.
And Judge, that, and I apologize, I already had the records, and so I wanted them to certify the records. I did not anticipate it would be an issue like this. And so I normally, when you serve a subpoena like that, they would contact us, and which they did. And I actually reached out to them to try and narrow this issue. I did not assume that it would turn it. I didn't mean to hide the ball on the dates or anything like that. Like it's the records we have that I wanted certified.
Well, I think we can't amend it after the fact, and so you can try to reserve it, I suppose, before Thursday. But the subpoena in front of me, I think, goes too far, or you can try to use the record certification you have elsewhere if you think that's
legal. What I can just do that, Judge. And we did file the returns, so I mean, we're not trying to hide anything.
Sure.
Filed the returns. That's, I believe, how they got them.
All right, Mr. Evans. So I'm granting your motion. Anything else you think we need to address on your behalf?
No, Your Honor. Thank you.
Okay. Thank you for joining us.
We'll miss your face.
Let me turn over to Mr. Banks, if you're still with us.
Mr. Banks. There you are, Gabe Banks. He also filed it.
I am, Judge. Good afternoon.
All right. Good afternoon, sir. Any particular order you want to go in?
I can address mine first, Judge. I mean, I'm sure the court has read the pleading. Ms. Merchant actually filed a response. I mean, in my pleading, as it concerns my motion to quash, of course, I represented that I have no personal or direct knowledge concerning the issues that are germane to this court or that are pending before this court. I mean, taking a glance at what the court has already discussed with Ms. Cross in the state's motion, I would submit that, I mean, if she's saying that I have relevant information and that at some point she has a witness to reflect that I have direct or indirect knowledge concerning the issues that are germane to this court, then, I guess we would just have to wait and see. I would submit to this court, however, that I don't. And I mean, it is a fishing expedition as it concerns me. I mean, I guess arguably if she wanted to question me about whether I was considered to be the special prosecutor, that certainly would be relevant. But based upon my lack of knowledge concerning any romantic relationship prior to her motions and the issues brought out before this court, I have no direct or indirect knowledge. And so I do think it's a fishing expedition. And of course, if she wants to respond and suggest that she has a witness that will contradict that evidence, then so be it. We can just deal with it at that time.
Okay. And I'd note, Ms. Merchant, that if it's solely to say that he was considered to be special counsel as well, excuse me, special assistant, that's going to go more into the qualifications area that I don't see as germane and necessary for an evidentiary hearing. But over to you.
But I think what Mr. Banks was kind of suggesting was that he sort of be like in waiting, with sort of a backup. And that's what I planned on for him anyway.
So if you join late, you need to understand that the judge has ruled that there will be an evidentiary hearing, and that is limited in scope to really the more salacious charges that have been raised in Roman's motion to have the to dismiss Fani Willis and Nathan Wade from the case. What he specifically, there's certain things that he carved out that he will not be entertaining as a basis for dismissal. They include, at least in this evidentiary hearing. So they include issues as to whether he was the appropriate choice, whether the basis of choosing Nathan Wade was because of their personal relationship, but he's focused, or whether he's qualified, and things of that nature. So you can understand why, in anticipation of that being an evidentiary hearing, Merchant would have issued a subpoena to Gabe Banks and talked about and said, I need you to come in and testify so I can basically explore why you were not chosen as special prosecutor and the job went to Nathan Wade. With respect to issues about the personal relationship, because what the judge said, we are going to explore this evidentiary hearing, is the nature of the relationship, whether it's romantic or not, when it began, and how much money has gone to Nathan Wade. Those are the issues that the court is willing to explore. So since he's limiting the evidentiary hearing to that, so it seems as if Gabe Banks probably won't be relevant because he doesn't know much about he was just another guy who was considered for a job. So he doesn't know anything about the romantic entanglements between Fani Willis and Nathan Wade. And he's like, I don't know what I can bring in here. And Ashley Merchant seems to be recognizing that, yeah, I did subpoena him for issues that you kind of have said you're not going to be taking testimony on. So I think she's going to say that she's okay with letting him go.
As far as some of Mr. Bradley's testimony.
Sure. But I'd also he has other clients and other obligations. And if there's really nothing of relevance, then I think we need to at least have some kind of, as we did with the other witnesses, an initial upfront showing of that. So as we walked through just at a surface level with the district attorney employees, what is it that Mr. Banks you think is going to testify to that that you're going to be either able to, he's going to go along with you, or that you're going to be able to impeach?
It depends on how they impeach Mr. Bradley. So he would be, there's some areas that they may question Mr. Bradley about, and Mr. Bradley has received phone calls from some people over the last several months trying to promote him not to testify. And so I don't know what the state plans on going into.
Well, and I can appreciate the need not to want to have to present your entire case today, but at the same time, I think we may need some more specifics, and if that has to be in camera, then we can do that.
It's just Mr. Bradley has received calls that he believed were trying to keep him from testifying.
All right, and those calls would be relevant and admissible how?
It depends on if he is cross-examined about it, but it's also his fear in testifying. That's something that the state regularly asks witnesses if they want to be there to testify. If they to the veracity for the court. He doesn't want to be part of this. He doesn't want to come and take the stand. And so I think when he goes into that, it'll be relevant to the court.
Is your contention that Mr. Banks made some of these calls?
Yes.
All right.
Ooh.
Okay, Mr. Banks, back to you.
That's interesting. You tried intimidating and yelling at Bradley not to testify. Why are you doing that? That's interesting.
I mean, I to the extent that I had conversations with Mr. Bradley about it, I mean, I mean, there's certainly conversations that I had. I called him, and I'm happy to talk about it, but I called him on a personal level because one, he's my friend, and two, he's my fraternity brother. And I know that ultimately these type of things are very stressful. I was concerned ultimately about him being emotional given his prior relationship with Mr. Wade, of not being able to see the forest beyond the trees when you actually are making decisions on an
He's sounding a lot dicier now, in my opinion.
emotional basis, and based upon my understanding that he had represented Mr. Wade dating back as far as 2015,
So he's basically admitting that I told him not to testify.
notwithstanding the fact that the divorce proceeding wasn't filed until 2021. It's my understanding that I was concerned personally as my fraternity brother and as another member of the bar that he might arguably be running afoul of the attorney-client privilege. And so
He did yell at him not to testify.
I did have a conversation with him about that and just expressed my concern. And if that was a way to intimidate, if that's what he's suggesting, I mean, I would take issue with that. And in fact, we laughed, and he said we need to get together for a drink afterwards. And so, but if that's what she wants to call me about is my conversation with Mr. Bradley, I'm not sure that that's relevant at this point.
Sure. Okay. Well, and I think that sounds like something that's just, we're going to have to see as the hearing begins and what we get through as
This sounds like it's going to be just a whale banger of a hearing.
to whether it becomes relevant and it becomes an issue. And so I don't think your motion would be able to be granted today.
I'm going to have to hold that in abeyance. We'll see what happens when Bradley. This is all hinging on Bradley. Everything is hinging on Bradley.
But we'll see. You can re-raise it at the hearing if you think it's necessary.
Okay.
I also think I would imagine you may have other, if you have other conflicts Thursday and Friday, I don't think it's necessary to have you waiting outside the courtroom for those 2 straight days. So we'll just put you on a 2-hour call if that works.
Well, the only conflict for the court's awareness.
That's what we're looking at, a 2-day evidentiary hearing. I will be covering this Thursday and Friday. I will be covering this Thursday and Friday. So I'm going to urge you, sign up goodlogic.locals.com so you can make sure you get links and be notified, because you're unlikely to get why you should subscribe here, certainly on YouTube and Rumble. You're likely not to get notifications about it. Likely to not get notifications. Where you can guarantee notifications is if you sign up at goodlogic.locals.com, as you see in the white down below here. goodlogic.locals.com.
This is
That's going to begin on Thursday, this evidentiary hearing. Thursday morning.
on the 15th. I have to be in federal court in Macon.
Yeah.
And so to the extent that you could get to me on one of those other days, that would be great and preferable. But I have to be in federal court in Macon at 1 p.m.
Well, we'll be in touch about any logistics. So as it relates to Mr. Campbell and knowing, I understand on the front end, is it a similar argument? I know
It
you
is a
raised
similar
the issue of
argument to Mr.
privilege.
Bradley, Judge, and based upon the court's earlier kind of discussion and colloquy with Ms. Cross and Ms. Merchant, I'd assume that they're not trying to go into attorney-client privilege. I will just take issue. I mean, it seems to Ms. Merchant's response seemed to suggest that because he wasn't counsel of record in the divorce, that somehow or another he hadn't gleaned information that was related to the attorney-client privilege. My understanding is that Mr. Campbell, or Attorney Campbell, joined the Wade law firm back in 2012. And
listen to this guy now, not only talking about his own quashel, but trying to say that Bradley, trying to weigh in as to whether or not Bradley is allowed to testify about this, about what he knows before he was retained.
that at or around 2015 is when, um, the issues concerning whether or not Mr. Wade was going to get a divorce with his current wife came up, and that the firm began to represent him at or around that time. And so to the extent that she's seeking to get into information concerning what he gleaned, albeit not a counsel of record, but a member of that firm, that I would submit that that would certainly be an issue that we
Shut
would
up.
be seeking to
It's not your
avoid him
argument.
testifying about.
It's not your argument.
Ms. Merchant, any response?
Judge, I want to make sure that I'm clear. There was also some allegations in Mr. Banks' petition that they were business associates. And so that I don't know if they were arguing there was some type of privilege. I can't find anything to indicate that they're business associates. And I couldn't find anything to indicate that Mr. Campbell ever represented Mr. Wade.
Isn't the firm Wade and Campbell?
Yeah, but they're not. But if you go to the bar website, it's not. And if you go to the Secretary of State, it's not.
Oh.
And
Oh.
to further complicate matters,
Ooh.
Mr. Campbell has a taint room conflict contract right now and has had it for the entire time Ms. Willis has been there. He is doing taint review under Garrity for Mr. Wade's anti-corruption unit. So I don't think they are partners, because I think that would be problematic for them to be doing taint review of privileged material that is being reviewed by.
Well, I think with those red flags, I think that's also worth noting that we've got two witnesses here, Mr. Bradley and Mr. Campbell, where privilege issues are being waived. And I think to the extent possible, we could burn hours getting into these issues. So I think we're going to have to be ready to address those efficiently in determining the scope and manner of the representations, or save them towards later in the presentation of the evidence. So, Mr. Banks, any initial, just on that last point about, is there any privileges as it relates to something related to their business association, or is the sole focus that may come up if he's called to testify relating to the attorney-client privilege?
I didn't, I used the word business partner because he is, that they are partners at this point in time, whether they were partners way back when they joined the firm, when he joined the firm in 2012. I don't think that was the case. Having said that, to the extent that he gleaned confidential information through the attorney-client privilege while being a member of that firm, it would be much like a paralegal wouldn't be able to, divulge privileged information while working.
Nobody knows. Nobody knows. Maybe they're playing basketball and he's like, yo, man, I am totally tagging the district attorney. No one knows. No one knows what the heck, how it is that he learned. They could have been at a ball game and he could have been bragging about the fact that he had the district attorney in his corner. Literally sitting huddled in his corner. We don't know. So he's sitting here speculating that, well, the source of that knowledge is through sitting on these meetings about a potential divorce. You don't know that. This guy's totally speculating. Squabob, new member of the following. Welcome aboard. The following is not at all a cult type of cult. Please disregard all the claims, even though people in locals are called diggers, and there's a whole story about the tunnels in New York. Do not think for a moment that this is at all a cult type of cult. There are no spaceships, no Kool-Aid, no mandatory tracksuits, no self-harm, no harming others, no squirrel mutilations, no goat sacrifices, no throwing virgins into volcanoes. This is not at all a cult type of cult. So please, and I'm not the leader of the following, because the people who become members are followers. They are followers, but it's not at all a cult type of cult. And I'm not the leader of the following. I'm just a follower, just like you. I'm definitely not the leader. I'm not the leader of the following. It's not a cult type of cult. Tracksuits will be available, not mandatory. Mild farm work may be required at some point.
ultimately with that firm. Now, that's as it concerns any information that he gleaned concerning the relationship between Mr. Wade and Miss Willis during the pendency of the divorce proceeding and prior to the pendency of the divorce proceeding. Frankly, I don't think that the attorney-client privilege starts when someone files an entry of appearance or files a complaint for that matter. I think
Sure.
attorney-client relationship.
All things we'll have to get through.
Yeah.
All right. But for today, I think there's at least that basic threshold showing of relevance where you may end up having to be called at
Yep, you're not out either.
this hearing. So I'll defer ruling as the record develops. You can re-raise it.
Nice.
Okay.
All right. Thank you, Mr. Banks. If there's
All right.
any,
Thank you, Judge.
all right. Take care.
Thanks.
All right.
I think we still have Mr. Partridge and Miss Monroe. So let me turn to motion to quash filed on behalf of Miss Yurdy.
All right, good afternoon, Judge. Durante Partridge on behalf of Ms. Sheridan.
Yes, sir. So
Noting that also, they're like, "There's no basis, no basis," and the judge is like, "But what? But this does seem relevant to what?" Yeah, but as soon as I gotta tell you, I just want to pause. We're an hour into this at this point. There's another half hour left. I just want to point out Ashley Merchant, unbelievable work. Really, really. This is a stressful thing, and I want to acknowledge her skills, which are prodigious. Her prodigious skills. And these other lawyers are trying to quash. They're trying to quash Ashley's subpoenas. They're failing. Mr. Totally Not the Leader, do we need shovels? Well, otherwise, no one's going to know their hours. I got here late. Will you recap at the end? I'll do my best. Yes.
it probably makes more sense to start with Miss Merchant on this.
Yes, Judge.
Yes, Judge, that's fine. Judge, Miss Yurdy owns the property that Miss Willis was staying at. She has an immense amount of knowledge that's relevant to this case about their relationship prior to Mr. Wade being appointed. In this case, they've been best friends since college for 30 something years. And
she's the one who Fani was gossiping about with respect to the size of Mr. Wade's portfolio.
has knowledge of the relationship. The relationship prior has knowledge of them staying in the apartment. She owns the apartment. So.
All right. All right, Mr. Partridge, in light of this conflict in the evidence over the relationship, what do you think the grounds would still be for quashal at this stage?
Yes, Judge. Thank you so much. First and foremost, just to clear discrepancy with what Ms. Merchant just said, my client does not own the property whatsoever. She was leasing the property at the time and subsequently moved out of the property to move into another property that she was renting as well. And Ms. Willis continued to reside at the property. So my client did not know anything that was going on at the property when she moved out. So just to clear that first and foremost, Shauna.
I'm sorry, Judge, rental. It was a rental. I said owns and I meant leased. So had authority over the unit. Sorry.
Yeah.
All right, Mr. Partridge.
Thank you, Judge. Furthermore, Yana, with regard to this situation, we called it a fishing expedition as well, merely because Ms. Yurdy does not have any information as it relates to that of a romantic relationship or any relationship or what took place at the property after she moved out. I've communicated that information to that of Ms. Merchant from that of Ms. Yurdy, so she just has absolutely zero else to add to.
Okay.
That's a factual claim. That's not a legal claim. That's not a basis to get out of quashing. Understand this. What is the judge dissecting here? Those of you who came in late, I'll try and help you catch up so that when you're watching now, you can appreciate what's happening. A motion was filed by Roman looking to say that there's a number of bases, that there's a terrible taint over this prosecution team, which precludes them from being able to go after Roman. Roman is a co-defendant of Trump in the Geaorgia RICO case. And Trump has signed on to these motions as well. So whatever Roman succeeds in, and Ashley Merchant, that's the woman in pink, who seems to be garnering a lot of attention from many people in my chat for her fine work in this case, has she issued subpoenas and said, we need to have an evidentiary hearing so this court can come to determinations as to whether or not there was improper taint here. Now, there's a number of different bases that they brought up as to why it is that they felt that there was problems here with Fani Willis. And what they're saying, essentially, the different arguments they raised include saying that he's not properly suited for this. He was only chosen because he's a boyfriend. That's the only reason he got this. He doesn't have the skill for it, the background for it. He's being paid more. He's and that essentially this is just a romantic entanglement. The court has agreed that an evidentiary hearing is necessary, and in expectation, before we get to what the court agreed to, in expectation that there would be an evidentiary hearing, Ashley Merchant, counsel for Roman, issued subpoenas to 7 members of the prosecuting team and other third parties to try and attain evidence that she would provide at an evidentiary hearing, which would establish that this relationship was ongoing. The court has said that they are going to conduct an evidentiary hearing to establish the nature of relationship, if it's a romantic relationship or just a business/professional relationship, and at what point in time that relationship began, and whether or not he's been paid money, which has now been being used to finance his relationship with Fani Willis, because that would seem to be an improper taint in the eyes of for this prosecution team, in the eyes of the court. So now that the subpoenas have already been issued, several of the parties who are looking to be subpoenaed are saying, we want this quashed. We don't want to have to be legally obligated to respond to these subpoenas. Most of the quashing is not about business records being turned over. Most of these subpoenas are about testimony at the evidentiary hearing, which is supposed to commence on Thursday, this Thursday, the 15th, probably at 9 o'clock in the morning or thereabouts. We'll know soon. So Yardley here is, and as Merchant is testifying, that she has all this knowledge about the relationship. They're college buddies. They go way back. Willis was staying in her apartment. Apparently Wade was coming there. Her attorney's coming in here and saying she doesn't know anything about this relationship. She doesn't know anything about that. That's a factual question. Maybe she does. Maybe she doesn't. If it's a question as to what are the facts here. Does she know anything? Does she not know anything? That's not a valid basis for the judge to quash, because he's like, I don't know. Maybe you tell me the truth. We'll only know that if she testifies. So you can't tell me she shouldn't testify because because you're telling me that what the facts are. I can't rely on you for the facts. If you have a legal argument to say that the basis is not relevant here, or there's some sort of privilege which precludes her from testifying, that's a different thing. And if that's the case, that would be a legal basis for me to say, okay, she can't take the stand in the first place. But if you're just telling me what she's going to say when she gets on the stand, and that she's going to refute everything that Roman's attorney Merchant is saying, well, let's let her take the stand, and then we'll see. So that's essentially what's happening here. A conflagration of lawyers is called either an eloquence, a disputation, a quarrel, or an escheat. Okay. I appreciate that. You see, you're learning a lot. You all learning a lot here.
Ms. Merchant, do you have anything that would impeach that testimony if that's what she testifies to at the hearing?
Yes, I think she has personal knowledge of their relationship.
And how would you impeach that?
I can impeach that with Mr. Bradley, but I believe that Mr. Yurgi will testify truthfully, and I believe that she will tell this court that she has knowledge of their relationship and has knowledge that Mr. Wade was staying.
Big Boop says, just a reminder for our YouTube followers lending a hand in the tunnels. In order to be a digger, you need to enter excuse me. In order to be a digger, you need to enter the next level, the not a cult type of cult, by subscribing at goodlogic.locals.com. Only then can you be a true digger. Diggers are very this is having fun there in the chat in locals. Goodlogic.locals.com. There's no Kool-Aid. That's pretty funny though.
Staying at the apartment that Miss Willis was staying at.
Okay, Mr. Partridge, back to you.
Yes, Judge. I would I would disagree as it relates to the representation that Ms. Merchant made. If there's any information or testimony that Mr. Bradley has, we'd also ask the court to reserve ruling as to Ms. Yerdy's involvement with regard to this particular situation to see what information comes from Mr. Bradley. Otherwise, Your Honor, this would be a fishing expedition because there's no information that Ms. Merchant has stated to the court that would suggest that my client has actual knowledge of a personal or a romantic relationship or Mr. Wade staying at the that particular residence with Ms. Willis.
All right. Well, just a matter of logistics here. Are you suggesting that Mr. Bradley should be allowed to go into statements he's heard from your client before she's called? Because generally you impeach someone after they've said something that they...
Yeah, that sounds like hearsay. This is a great question by the judge. I'll tell you right now, I don't always agree with this judge, but I do have respect for the fact that he seems to be doing an effective job of trying to parse out legal issues appropriately. So let's think through how you're asking us to do this. We can't have him come in here and testify about what your client knows because that would be hearsay. Now, if she first comes in and testifies about what she knows, in that case, there would be some sort of, then he'd come in to rebut and use hearsay to rebut her. That would be an exception for purposes of rebutting a lie. Someone can come in here and say, well, she told me something else. And that would not, and hearsay would not be a valid objection. So he's like, what do you want me to do here? You're telling me you don't want your client to come in. Okay, I get that. And only come in as a rebuttal witness. But then how's he going to rebut if you don't want your client to take the stand? So what do you want? What are you asking me to do here? Great job by the judge. He's thinking this through. So this lawyer represents to the court that I think it's Yerdy, I don't even know, will say she has no knowledge of Fani Wade relationship. If Yerdy does testify she knows the relationship, could the lawyer be sanctioned? No, that's not going to happen. It's not going to happen. And she'll be like, I misunderstood her or whatever.
Can be impeached with, right?
Yes, Judge, and I understand that, Your Honor. My concern, however, is that there's nothing that we've been presented with. There's nothing in the subpoena to Ms. Yerdy that says or indicates that she has, any information beyond that of what Mr. Bradley has said to that of Ms. Merchant, which is essentially all that we have, all that I've been put on notice about, is that Mr. Bradley, is the person, or rather, before today, it was there's another witness, a lawyer that has something to say as it relates to that.
Sure. So if Mr. Bradley were to testify as, say, the first called witness, that he had a conversation with your client without going into what it was or what the substance was, and that generally that conversation contained information about the nature and extent of the relationship, is that thing going to open your client up to being called?
It potentially would in that situation, Your Honor, but I guess we'd have to get to that point. I'm not sure what
he sees, that he's stuck in this conundrum. He's stuck in this conundrum. I can't keep my client off the stand. At what point, what am I supposed to allow this guy to say that would not going to be considered hearsay? What am I going to allow him to say that now your client's, he has to talk about this now? That's what you're telling me to do. And that's going to be a hearsay issue. The other side, everyone's going to be screaming hearsay. If she starts asking Bradley, did you ever talk to Yerdy about the relationship between Wade and Willis? So in that case, what the other side's going to say hearsay. So you're telling me I shouldn't bring her up on the stand because it's not relevant. She doesn't know anything. Well, how do we know this? You're putting the cart before the horse.
Information he would have. I've not had the opportunity to reach out to Mr. Bradley, who I know also, Judge, and so I'm not sure. But according to my repeated conversation with Ms. Yerdy, there's no information as it relates to her knowledge because, again, she moved out of the condo or the residence.
Okay.
Moving out of the condo doesn't mean she wasn't talking to her at all. And it's kind of ridiculous to assume that she was.
Just there's another issue. There's also, in our brief, there's also this issue of the, and I know we weren't focusing on that, so I didn't highlight it, but there's also this issue of the media statements, all of those types of statements. So Ms. Yerdy, I think this is instructive for the court. Ms. Yerdy was the person at the DA's office who actually had an account to monitor the critical mention media. So Ms. Willis, had a contract with a company called Critical Mention. And what they are is they're a media monitoring company.
Sure. And remind me, is your argument just to say that that is a motivating factor in this case and is underlying her forensic comments?
Oh, yes, definitely, Judge. Yes.
Okay.
And Miss Yurdy's the one that actually had those reports. There were two people that had access to it at first, and Miss Yurdy's one of those.
So just to clarify, in case you're confused as to what's happening right here and now. So one of the issues that the judge says he's not going to allow in this evidentiary hearing are claims that were made by Roman that the reason that Fani is pursuing this is for her own financial and or fame, to benefit herself financially or through her fame. And they talk about the fact that she's gone on she made 38 appearances on TV. She had this widely broadcasted speech that she gave in a church where she was tainting potential jury pool by basically painting herself as if she's been the persecuted one here. They're coming after me because I'm trying to do justice. Lord, your stubborn child, your flawed, stubborn, hard-headed child is not going to give in to those who are coming after her. Give me the strength, Lord, as they try and come after me because I'm a black woman, and some people are not used to a black woman. They didn't go after the white man. They're only going after the black man and the black woman. So the judge said, I don't want to hear about that part of it. That's not part of this. That's not part of this. So now when Yurdy has a role as being part of her whole, I don't know, PR strategist. So he's like, I don't want to hear testimony about that. But if it's designed to impeach and say that, that when she's saying that she has no motive, that changes things a little bit. Thank you, Gary. Appreciate you.
So she's one of the people that responded to Miss Willis and would give her these reports and talk about these reports with her. But she also, the critical information is that this is her place.
Sure. So understood. And I'm thank you for
point is to impeach not about the PR element, but the fact that you're all claiming that she's not in that premises anymore where Willis was staying. She's there all the time. Even if she moved out, she's still there.
Flagging that, I think that's likely to fall solely within that box of things I don't think would be coming out in an evidentiary hearing in terms of the forensic misconduct, but we'll take it as it comes. All right, Mr. Partridge, thank you for joining us today. I don't believe that I can grant your motion to quash at this time.
You're in also, Yurdy. We're going to have them all. Bring them on down. Bring them all on down. There you go, Judge. There you go.
Understood, Your Honor. And if I may, just for the record, Judge, there was something else mentioned as well. I believe when Ms. Cross was presenting, Ms. Merchant stated that Ms. Yurdy was the personal assistant and kept calendars for that of Ms. Willis, and that is also untrue, Judge. Just for the record, she was not an assistant, Your Honor. She did styling for Ms. Willis as well as some public relations work for Ms. Willis during her campaign, Your Honor.
Okay. Understood.
Thank you.
Take care, Mr. Partridge.
Sit down, Partridge.
Hold up.
Reaching out to Mr. Bradley. Mr. Bradley has retained counsel. He does not want people to continue to reach out to him. So I would just please put everyone on notice that he does not want everyone to keep reaching out to him.
Who is this counsel?
It's BC Chopra.
Can you say that one more time and spell it for the record?
Well, he goes by BC Chopra. It's Bimal, Bimal. His last name is Chopra, Chopra.
Okay.
And because he was getting calls from people
Sure.
who were under subpoena in this case.
All right. I think that leaves us then with Ms. Monroe on behalf of the DA's office as well.
Yes, good afternoon.
The Fulton County Attorney. Okay.
Okay, so thank you, Judge, for putting this case on your motion calendar on such late notice. So the reason for our motion to quash is, number one, these documents that were requested have been provided to the defendant's counsel by way of the Fulton County portal. We
All
have
right, let's go into specifics. I'm looking at a copy of Exhibit A of the subpoena. It's got 7 bullets. Which of those are you contending have already been provided?
So it is our I don't know this specifically, but it's our understanding that about a majority of the responses have been provided. and viewed by defendant's counsel. And if not provided directly through the portal, it has been attached to the various motions as supporting documentation in this case, and also readily available by public information.
Well,
the sec-
which ones haven't been though? Because that could still be relevant for the subpoena.
It's our understanding that I don't have that direct information, but in light of the responses that have not been provided, there is no relevance for the information. We have a criminal case. The things that they're asking for there's no connection. There is no relevance, and the defendant admits that there's no reason in which these documents there was no reason provided as to why these documents were requested.
Which documents?
And in order for
Which documents?
in order for a subpoena to be issued in this fashion, there needs to be a material reason for the subpoena. And in this case, we do not have one.
Which document?
Okay, Ms. Merchant, what haven't you gotten that was on Exhibit A, and why is it relevant?
So I have not gotten all of the invoices from Mr. Wade. I started asking for those back in September through the open records, and I got some of them.
That's what I really want. I am very confident that these invoices are going to show that he was billing for time that he spent on vacation with Fani.
Piecemeal. I got a couple others that the state attached to their motion. So the open records officer said I had gotten everything, and then the state attached a couple more. So now I have even more, but there's still a couple that are outstanding. So there's several that are outstanding, and we put that in a very detailed pleading and letter to the Fulton County county attorney. We have not received a single invoice for Mr. Bradley. We do not have a current contract for Anna Cross or John Floyd. And the issue with that is that Ms. Willis made statements that she paid them the same amount of money. The contracts we have for Mr. Floyd, that is an incorrect statement. He was not paid the same amount of money. We do not have either current contracts for either of those folks. We don't have anything about the time off requests. We don't have anything about the reimbursements for Ms. Willis. And we don't have anything in regards to the last bullet point.
What makes you think that travel reimbursements
The
are relevant? Because everything seemed to be personal travel.
No, well, Judge, we're not sure that it's all personal travel, and I don't believe that it is. This is all evidence that is related to us showing that Ms. Willis had a personal and a financial interest in this prosecution. Reimbursements for her travel. We have some reimbursements for Mr. Wade's travel. So are those trips connected?
Locals.
Those were the things that we're
Yeah,
seeking.
find me, Diane.
We sought all of these through
Locals.
open records.
Project.local.
These are open records, but the county has been refusing to give them to us despite way longer than 3 days. So before this hearing was set, we already were in litigation over the open records violation. These are things we're entitled to. We don't have to show that they're relevant in the open records context.
Sure.
But so then we get a hearing, and instead of waiting for the litigation and them to actually give us the documents to the open records, I have to get them in through a business certificate. So I can't submit an open records. So I cannot submit all of these invoices. These invoices are hearsay. I need a business record certificate. I sent a subpoena to the county asking for a business record certificate. They have to certify the documents they've already given me. Plus, they've got to give me the documents that they haven't given me.
1 through 18. Invoices 1 through 18.
Let's keep making our way down the list. I can see your argument on travel and vacation, since that's at the core of your allegations. The last one, though, talking about all hiring and outside counsel, that seems to go more towards what I'd indicated has a lot less relevance for me.
Hiring an outside counsel for...
Just generally, it says any outside counsel, process for hiring bids, payment of outside counsel.
Yeah, that does seem
Are you talking about, and I just want to make sure...
The final bullet. Any and all course.
Oh, okay. I understand. I want to make sure, because I printed theirs out right before I left the office. This is in regards to a Board of County Commissioners meeting that was held in November 2023. There was a very detailed conversation between Dexter Bonds and I can't remember her name, but she's the purchasing director for Fulton County. They had a very detailed discussion and said that there had been a problem with the processing of invoices with the district attorney, and that they had to talk with her and go through a new rebidding training with them, because essentially they were having services that weren't going through the proper channels. We believe that these documents are relevant to show the personal financial interest of the district attorney.
How so?
Getting things paid for without approval.
Okay, so that's going.
By the way, notice how they changed they don't have the camera anymore. They changed cameras.
More towards the approval aspect of it,
think it's
and the
appropriate.
maybe county, what you would refer to as impropriety and sticking to county regs. Is that fair?
Not necessarily county regs, but also sticking to the statute, which is the basis for all of this. The statute that was not followed, which is the basis. But also, what are these? Is
I
she
know.
having a personal financial benefit?
That's some snatch. Very good job, Evan. Great job, Evan.
To this prosecution by submitting invoices and things like that.
I just want to add and just provide further clarification. It's our understanding that pursuant to the subpoena and the information that's being requested there in our possession, Fulton County Attorney's Office, all of that information has been provided. But in terms of the open requests that were submitted, the separate open requests that were submitted to the District Attorney's Office on a separate open records request, we wouldn't have personal knowledge as to what requests have been fulfilled or not. But in terms of what we have in possession in our office, we have that information has been provided already by the District Attorney's Office. So there's nothing outstanding pursuant to this subpoena that we would have that they don't have access to already.
Okay, so just to be.
I don't have anything authenticated. I haven't received one single authentication from them.
And I think that's what it comes down to. She's seeking authentication. We just want to make sure that we are fulfilling our end. And if this is information that she has already received by abusing the legal process with subpoenas just to obtain authentication, is not a proper use of the legal system, nor is it coupled with the fact there is a pending litigation, as Ms. Merchant.
Seems like the judge seems pretty confident this is not an abuse of the legal process by the defense.
So emphasize pending against the District Attorney's Office regarding an alleged Open Records Act violation.
Well, how else would she authenticate it then, Ms. Monroe? Were you planning to come down and have someone personally testify to it?
Without a subpoena? That's what.
I'm sorry, I didn't hear the question.
Well, I mean, more to the point, it seems this conversation keeps shifting. It's either the county attorney does not have the items requested, or is the sole issue now just authentication of the items that she already has, the defense already has?
Your Honor, may I be permitted to speak? This is Shalonda Miller. I am the designated records custodian for Fulton County.
Okay.
And I might be able to provide some clarification. Individuals request open records. We are not required to authenticate responses to open records requests.
That's why
That's not a part of the Open Records Act. You're also not required to produce anything that we do not have in our possession, even when individuals think we do. I'll give an example there, Ms. Merchant.
No, I agree with you. I don't need an example. But I guess all that would remain then is what Ms. Merchant is saying, that if all she's after is authentication and that hasn't been provided, but she thinks that a witness she
Never
has subpoenaed.
requested authentication, Your Honor, absent this subpoena. That
All right.
wasn't a request. The first time we saw anything about authentication was at the service of the subpoena.
Because
Okay.
that's what she would get.
All right. So, Ms. Merchant, where does this stand then?
Judge, it's two things. First, that's how we have to get business record certificates, is we have to subpoena the witness. And if they want to avoid coming and testifying, they can submit a business records affidavit. We drew one up and submitted it with the subpoena. So I believe we followed the proper procedure to get these records certified. As far as that they've given us everything they have.
What they're arguing about here now, in case you're confused, which you likely are, is that so we have all these records with respect to bills that were presented by Nathan Wade to Fulton County and how much money he got paid and how much money they paid, and they're able to pull them from the portal. But how do I establish that this is not hearsay? Well, you can So when I'm going to put them up on the stand, the opponents of the motion, the state, are going to could in theory, in the moment, say, well, this is hearsay, that these are actual records. I'm going to say I pulled them from the. So what am I going to respond at that point? Well, I'm going to respond, well, I pull these from your portal, you sent them to me. Well, is there an affidavit saying that they're accurate? No. Well, if there's no authentication, so in that case, you're going to say it's hearsay. Well, what's an exception to hearsay? There's something called a business record exception to hearsay. Business record exception, because, even in general, we deal with business records all the time. Any business record is technically almost always going to be hearsay. It's purporting to convince the finder of fact that what it's showing in that document is the truth as to what happened. How do we know that he got paid this much money? Because we have these business records. So those business records are a form of hearsay, but they have a hearsay exception. There is specifically a business record hearsay exception, but you need to establish a few things in order to get that exception. What you need to establish is that this is records that a business maintains in its normal course of business. It's just generated automatically. And that you oversee the operation of it, and that you pull the files properly, and that this is, you might indicate what type of search you did, but you need to sort of establish that there's a process and a procedure for maintaining records, and that they were kept in their normal course of business, and that this is what your business records are reflecting. That gives you now a business record exception, that there's no hearsay issue with the documents that are being presented. So now they're getting into the technical nitty-gritty here as to okay, so when I try to present these invoices to the court as evidence, if I pull them from the portal, there's no business record exception. I have to subpoena someone to come down and testify about it and say that this is a business record exception. What's another way around that is if the state were to admit that they have something that swears to it, they authenticate and say these are the actual business records. So either way, either someone's got to come in here and testify, and she's completely correct on this, and the judge is going to give her this one, is that she either needs to have it authenticated by someone coming and testifying that this is the normal business record and therefore an exception to hearsay, or basically have an admission from the state that this is going to be okay because this is authenticated by the state itself. And this is the government protecting itself, yes.
They have not. As far as the first bullet point, we do not have invoice number 22 or 25. It's not been attached to anybody's pleadings. It's not anywhere, any place.
Okay, let's start there. So, Ms. Monroe, is invoice 22 or 25 something that's in the possession of Fulton County?
Not that we're aware of, Your Honor.
You don't have he submitted bills to you and you don't have records of what he submitted to you?
Who would typically have retained custody of those kind of things, those invoices or reimbursement requests? Would that just stay with the district attorney, or would Fulton County have all those?
The district attorney, and we'll follow up with our client, but it's our understanding that they provided the records they do have. I'm not sure why and R25 not be a part of those records.
This is the dog ate my homework excuse.
But we can confirm that all that we have in our possession has been provided.
Well, you need to swear to that.
And Judge, I've been asking for invoice 22 since September.
Okay. All right. And Ms. Merchant, you were talking about, you said that the next three bullets were invoices for Mr. Bradley, contracts for Ms. Cross and Mr. Floyd. I guess turning to Ms. Monroe or Ms. Miller, are those also things that you're saying are not in the possession of Fulton County and only in the possession of the district attorney?
We're not trying to delineate between the district attorney and Fulton County. What we're saying is our clients provide us those records, the records that they have in their possession. There are presumptions about what should exist and what we should have in our possession. But just because individuals think they exist doesn't mean we necessarily have them in our possession for whatever reason.
Okay, understood. Do you have them though?
No, not that we're aware of. And we have conferred with our client, and it is our understanding that everything that is in the client's possession has been provided.
Okay, so then that sounds like a follow-up question to their client, the district attorney's office, if they've been under subpoena for these same documents. But for now, the person subpoenaed is saying, or the entity subpoenaed is saying they don't have them. And unless counsel has a reason to show that they do, I think that's usually the end of it.
Ms. Cross appeared today. I believe, under contract. She's been submitting invoices. So, I mean, maybe they just come and testify as to how they have people
Well,
under
no,
contract.
it's not that it doesn't exist. It's where is it? And have you subpoenaed the right entity or person?
Well, they have represented that they represent the district attorney. They even filed this motion to quash saying they represented the district attorney. So
That's a
don't-
very good point. So Ms. Miller, Ms. Monroe, regardless of whether they're
Thank you.
down the hall or across the street, if you are the entity where legal process has to go in order to serve the district attorney's office for production, how does that get you out of complying with the subpoena?
Your Honor, I'm so sorry. I don't mean to interrupt, and you can tell me to wait, and I will gladly do it. But insofar as we're talking about a subsequent contract for me, there is none in existence.
Okay. And that's again, I keep hearing two different things. Either it exists or it doesn't exist, or someone has or doesn't have it. And then we keep flipping back and forth between the two. And I'm trying to nail this down.
Apologies, Your Honor, for being unclear. Anything that we have in our possession, that our client has in its possession, we have provided.
Okay.
There are assumptions about things that we have
We understand about
that are
assumptions.
inaccurate because we've provided everything that either our office or the district.
Are you
attorney's
supposed to
office
have it
has.
and you lost it?
Okay.
We're not trying to hide it.
No, that makes it clearer. So that you're saying that you would be, either you or collectively the DA's office would be responsible for providing these if you have them. And your understanding, just again, going back to the first bullet point, is that a invoice 22 or 25 has already been provided.
It may not have been provided, Your Honor, but if it hasn't been provided, it's because we don't have it in our possession. And when I say we, I'm saying a collective we, the district attorney's
thank you.
office. or-
Okay. Thank you. I think that's where I've been getting held up. Okay. But that's something you plan to follow up and confirm.
We will definitely follow up we have followed up numerous times with our client, but we will again for the
We're going to circle back on where these records are.
purposes of the court here.
All right, fair enough. And as for the remaining items, contracts with Floyd, Cross, Bradley, is it the same thing that collectively you either think they've been provided or they don't exist?
Correct.
All right. Ms. Merchant?
We would just ask that they come for, I mean, obviously they can't do a business record certificate to say something doesn't exist. So I think it just makes sense then for me to not even ask for the business record certificate and ask them to just bring the certified documents, whatever they have, and testify on the 15th about this. Seems the only way to figure out what exists, doesn't exist, existed. I mean, invoice 22 has been paid. Invoice 25 has been paid.
Sure.
So someone has them.
Someone got them.
Okay, so I think ultimately it's if there is something that you are being compelled to provide.
And I'm not going to kid you. I'm very baffled why it is that Roman's attorney Merchant isn't more bothered about invoices 1 through 18, which we haven't seen anywhere, unless they have them. But I'm very curious about invoices 1 through 18 because those cover the period of time when when Willis and Wade were going on their fancy trips. So I'm not sure why it is that seems to be something we hear very little about.
That does not exist or that has already been provided, and you can confirm that, then there's no obligation on your part to do anything further with the subpoena. However, it appears that in order to complete the evidentiary record, counsel needs at least some kind of testimony establishing the absence of a record, or testimony authenticating records that have already been produced. And so if there's not going to be a certification to that effect, then there would need to be live testimony to that end.
And you're going to have to get
And
your
so I
on
don't
down
think
here.
that an outright quashal is what happens with this motion or Fulton County.
Translation from the judge, you lose again. Another one coming on down.
Understood, Your Honor.
If there are other particulars that come up between now and Thursday, and you
know.
think you want more guidance or clarification, we can take it up.
Thank you.
Thank you.
Okay. All right.
Can we
Thank you all
get
for joining us.
Screenshot?
Of course. Thank you.
Thank you.
Thank
Have
you.
a good afternoon.
All right. Are there any other? I
Quash.
think we got through them all. Anything else? Anyone else here who anticipated needing to address before Ms. Cross? Anything else?
Just a minor logistical point, Your Honor.
Yes, ma'am.
At any evidentiary hearing on Thursday, we would ask the court's permission to have a witness who's out of state testify remotely.
All right. Can you identify that witness?
Yes, it's the district attorney's father. His name is Mr. Floyd. He's in California.
All right, Ms. Merchant, is that something you're prepared to address at the moment?
If I can speak with him ahead of time, then I can,
I think your spidey senses are well attuned, my friend. Well attuned.
very likely to agree and not object to that, and waive the notice that we're.
By the way, I highly recommend that if you need any transport, that Crispy Lake Transport LLC is the company for you. So make sure that you check out Crispy Lake Transport for all of your transportation needs.
All right.
But I just asked that I be
And I just made that a tax deductible super chat for you. There you go.
allowed to speak to him ahead of time.
Okay. And Ms. Cross, is that solely for logistical reasons, or are there other perhaps medical concerns or other things that might compel remote testimony?
There are medical conditions, as I'm aware, none that affect the witness's ability to appear. But I believe there are some medical issues involved in addition to the out-of-state travel.
Okay. Understood. I'll let you and Ms. Merchant take that up, and you
Thank
can
you.
let me know if that's something we still need to address before Thursday. As I mentioned, we've set aside all day Thursday. We've also set aside Friday, and we'll see if further time.
I have also set aside Thursday and Friday because I will be live streaming this hearing. You bet your bottom dollar. I am going to be live streaming the heck out of this thing Thursday and Friday. You're not going to want to watch on your own. How many things do I have to walk you guys through? You're not an attorney. You try figuring out what the heck is happening here. I don't know how anyone would follow it. So I urge you, join me right here. If you want to know the time, start time, and be sure you get notifications about it, because let's face it, Thursday's a few days away. In between, you might end up, forgetting stuff. Who knows? Things happen. You might forget stuff. So, yeah, that's goodlogic.locals.com. You'll get your notifications. Just pop up at you. Boom, in your face. Boom, boom, boom. Joe's streaming the evidentiary hearing of Fani and her salacious affair with Nathan Wade. Because she's persecuted. She's so persecuted.
Is required depending on where the hearing takes us in terms of
That's right.
logistics.
I'll try to get there.
I know a number of defense counsel have adopted the motion and joined it. Many of them are with us today. Ms. Merchant, have you had any conversations with counsel as to how you would proceed? Are they all planning to have you as their flag bearer? Or are they all, and when it comes to arguments, when it comes to,
And if you go there, I'm thinking about opening a testimonial section. Testimonials like this. If it wasn't for Joe, I would be stupider. There you go. Thank you, Ben. I appreciate that. If you're looking to supply a testimonial, we would love to have more testimonials over at goodlogic.locals.com. If it wasn't for Joe, I would be stupider.
director cross-examination?
I haven't had that specific question. I think that I'm probably going to be leading it, but I'm not sure. They filed a little bit different motions. Some of them had some different allegations, so they may have their own issues. As far as that, I did have one housekeeping matter, though. Mr. Wade has not accepted service of our subpoena. The state raised that in their motion. Since he has a lawyer, I reached out to Mr. Evans, his lawyer, and asked him if he would accept it on his behalf.
He hiding. There's nobody here. Go away. Go away, Mr. Service Process. Mr. Process Server. Go away. Go away now. There's nobody here. We don't know any Nathan Wade. Evading service. Man, this is their experienced RICO prosecutor. Evading service. Oh, that's hilarious. What a loser. She's like, yeah, can you just sort of like direct that he's now hereby subpoenaed?
Didn't want my process server to have to follow him around. I hate having lawyers do that, but I just need some direction if he's going to accept the subpoena or if I need to have him staked out.
So there's an alternative means of services. They're not, you can serve as counsel of record.
Yes, I can serve it. Well, in civil, I can. They raised an objection in Ms. Cross's motion to the service that I'd sent by certified mail, and he keeps refusing that service. So the alternative would be for me to either serve his attorney with permission of his attorney, Mr. Evans, or
I don't even know if it requires his permission. I don't have the statute handy at the moment. Maybe someone else can pull it up, but it's about 2 code sections following
This is hilarious.
quashal. So 24, 13, 25. If you can pull that for me.
What an embarrassment for the left this guy has become. Now he's evading service.
I mean, if he's accepting service, then it would obviously be easy, but I don't know if he is.
He's evading service.
But what I'm curious about here is if it matters whether his attorney is accepting or if you just send it to a certified address, if that's sufficient.
Can you just direct public notice?
Law says if we send it certified, that is sufficient. I know that the statute, I actually did print that statute out. He's refusing service though. So I think that they could raise that because they raised it in their brief. They're raising that it wasn't.
Well, if the lead counsel in this case is refusing service, I'll entertain a motion for a continuance until he can be properly served.
Okay, thank you, Judge.
Your Honor, before we go, can I correct something?
Sure.
I misspoke when I said that Mr. Floyd had medical problems that might prevent his travel. That's not the case. It's just his location in California that would require the remote participation with the court's permission.
All right. Thank you, Ms. Cross. Anything else, Ms. Merchant, you said is housekeeping?
Mr. Gillen said he is going to be presenting a summary witness, but that's it as far as just for housekeeping. A summary witness, hopefully to summarize all of the financial records, so it's a little bit easier.
Okay.
Thank you.
All right. So again, I would ask you to confer with counsel to confirm whether everyone's expecting to do their own argument. If so, we're going to have some time limits. If other people are presenting their own witnesses, I haven't heard of any because I haven't gotten any other motions to quash, and whether folks are combining their ability to cross. I think if they've joined the motion, they have the right to present their own evidence. I think I can limit argument to some extent. And again, I can very much, as we get through cross, if a question's already been asked, I don't really care who's asked it, and we'll streamline things that way. I think someone from the gallery wanted to be heard.
Yes, from the gallery, Your Honor.
If you could identify yourself for the record.
Yes, Steve Sadow, counsel for President Trump. When you're finished, I have a unrelated matter I'd like to take up with the court outside everyone else's involvement.
And is this ex parte?
It would be ex parte, yes, sir.
All right. Anything else? If not, we'll be off the record.
Okay.
Thank you.
All right. Well, there we go. So looks like we're getting an evidentiary hearing, and that's going to be commencing on this Thursday, February 15th. Who says there's no such thing as Valentine's Day? Oh, man. I've fallen in love with this judge. Not that and just to be clear, I question why it is that he has omitted any opportunity for there to be an evidentiary hearing with respect to the taint of the jury pool and the 38 appearances that Fani Willis has made and plus her church chat thing there, where she portrays herself as being persecuted, which this was seemed clearly motivated towards tainting potential jurors into being sympathetic with her for the purposes of convicting Donald Trump, which seems to be a very gross and egregious abuse of her position as a district attorney. But I think that we're going to hear plenty of gross and egregious things about Fani Willis on Thursday. I'm looking forward to it. And you should be too. So make sure you sign up goodlogic.locals.com. You'll get notifications about when and where I am, when this evidentiary hearing is. I will be streaming, God willing, this evening at 10 p.m. And I urge you to check me out then. So till then, I thank you all for joining me. Make sure that you like and subscribe on your way out. And I'm just going to share with you all. I think I covered everything. We did as I'm landing my plane here. Yeah, we all good. All right, we're good. Let's get on out of here. And I thank you all for joining me. Take care of yourselves. Stay happy. Eat some bugs. And as always, my friends, I say to you, Godspeed.